Good morning, ladies and gentlemen. How is everyone? Having a good time in Jakarta? Yes, we are happy to, and also we are so proudly welcome you from the RI Headquarters Conference Hall in Jakarta, Indonesia. Welcome to the 32nd ABU Intellectual Property and Legal Committee IPLC Conference. Ladies and gentlemen, today's conference will be having the theme AI, copyright, and royalties in the digital content economy. But before we begin, please join me in welcoming our distinguished guests. The first one is the Chair of RRI Supervisory Board. Please welcome Bapak Anwar Mujahid Adi Trisnanto. Ladies and gentlemen, please welcome the Director of Program and Production of Radio Republik Indonesia, Bapak Mistam. We also, of course, would like to welcome the Chairman of LMKN, National Collective Management Organization, Bapak Marcel Siahaan. We would like to welcome the ABU Director of News. Please welcome Mr. Indra Singh. Chairperson of ABU IPLC, Mr. Haruyuki Ichinohashi. And of course, in this very good morning, we would like to welcome all board members of the ABU IPLC, honorable speakers, delegates, and representatives of broadcasting organizations from across Asia Pacific. Ladies and gentlemen, to make this morning warmer, we know Jakarta is very warm, but we would like to make it hotter with a very warm welcoming remark from the Program and Production Director of Radio Republik Indonesia. Please welcome Bapak Mistam.
Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi. Good morning. Apa kabar? How are you today? Saya berharap kita semuanya dalam keadaan sehat walafiat. Distinguished Mr. Indra Singh, IBU Director of News, Mr. Haruyuki Ichinohashi, Chairperson of the IBU Intellectual Property and Legal Committee, IPLC, Head of Supervisory Board, RRI, Bapak Anwar Mujahid Adi Trisnanto, Head of RRI Jakarta, Mr. Bugi Hidayat, Mr. Marcel Siahaan, dalam perjalanan. Selamat datang, selamat pagi. Chairman of the National Collective Management Organization for Related Rights Owners. Selamat datang juga kepada Mas Ahmad Iqbal dari DJKI Kementerian Hukum dan HAM. Distinguished members of the IBU Intellectual Property and Legal Committee, IPLC, honorable speakers, delegates, and representatives of broadcasting organizations from across the Asia-Pacific region. Ladies and gentlemen, welcome to Jakarta and welcome to RRI. As the host broadcaster, RRI is deeply honored to welcome all of you to RRI headquarters for the 32nd IBU Intellectual Property and Legal Committee, IPLC, conference and meeting. It is a great privilege for us to host this important gathering of broadcasting professionals, legal experts, and policymakers from across the Asia-Pacific region. This year's conference focuses on the timely and critically important theme, AI, copyright, and royalties in the digital content economy. We fully recognize that the rapid advancement of artificial intelligence, AI, is transforming the media industry in unprecedented ways, while AI opens remarkable opportunities for innovation and creativity. It also presents complex legal and ethical challenges. This include the copyright implication content and maybe meaning implication of AI training data, question surrounding the authorship of generative AI content and editorial accountability within increasingly algorithm-driven and environment. Beyond AI-related issues, this committee also faced significant challenges in protecting broadcasting rights, combating digital content piracy, and ensuring fair, transparent, and sustainable royalty distribution for broadcasting organizations and content creators. In responding to these challenges, none of us can succeed alone. We need meaningful dialogues, stronger regional collaboration, and greater harmonization of legal and regulatory framework among ABU members to safeguard the future of our broadcasting ecosystem. I would like to express my sincere appreciation to the organizing committee, our distinguished speakers, and all delegates who have come together to share their valuable knowledge, experience, and perspective. I am confident that the discussion over the coming days will distribute significantly to the strengthening intellectual property protection and legal governance within the broadcasting industry. I wish you all a productive and successful conference. May this meeting foster meaningful collaboration, generate innovative solutions, and strengthen the legal framework for the future of broadcasting throughout the Asia-Pacific region. Thank you. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you very much, Pak Mistam, for such insightful welcoming remarks. And now we would like to invite the ABU Director of News, Mr. Indra Singh, to deliver his welcoming remarks.
Selamat pagi, very good morning, and bula, as they say in my language. First of all, before I start, it's an utmost pleasure to be here. Thank you very much, RRI, for putting together such a beautiful conference for us to all be part and parcel of it. And always great to be in Indonesia and visit the lovely places apart from the conference, etc. So thank you once again to all of you involved in putting this together. Head of Supervisory Board for RRI, Mr. Anwar Mujahid Endi Krisnanto, Director of Program and Production, Mr. Mistam, Head of RRI Jakarta, Mr. Bugi Hidayat, not forgetting the President Director of RRI, Dr. Ignatius Hendrasmo, all of the RRI staff, the Chairperson of the ABU Intellectual Committee, Harusan, distinguished legal experts, leaders, colleagues from the Asia-Pacific region, and all of those watching online. Ladies and gentlemen, it is my distinct honor to welcome you all to the 32nd ABU Intellectual Property and Legal Committee Conference. I was just sitting down and realized 32 years, that's a long time, and one of the oldest running ABU events that we do host. I stand before you today to deliver these opening remarks on behalf of the Asia Pacific Broadcasting Union and our Secretary General, Mr. Ahmad Nadim, who sends his warmest regards and highest expectations for the crucial deliberations taking place over the next day and a half. Our theme this year, AI, copyright, and royalties in the digital content economy, resonates very well with public broadcasters, in particular, those who continue to face the struggle of fighting and trying to get more revenue through the doors. We are living through a profound paradigm shift. The integration of artificial intelligence into the media landscape is no longer a distant projection. It is here and it is with us right now. From automated newsrooms to AI-driven content to synthetic media generation, the technology is offering access and possibilities never seen before, but with it comes the legal complexities. As public broadcasters and media professionals, we operate at a critical intersections. We must be innovative, but we must also protect the integrity of our content and of our newsrooms and media houses. For decades, the bedrock of journalism and content creation has been simple, with ethical principles in place and the value returned to the creator. However, this is fast changing. Today, generative AI models are trained on the vast high quality and verified archives of traditional broadcasters. Yet, the legal frameworks that are supposed to govern this data is ingested. How is copyright being recognized? And how fair are the royalties that are coming back to media houses who are creating content? With ABU representing over 220 member organizations, it is also learning of other sister unions like the EBU, which recently launched its Facts In, Facts Out, which has been on the forefront of how we can take the big tech giants to task for using our content. Probably a discussion that we can go on and on about, but all this for broadcasters and for media houses is not possible without you. Without the legal brains, without the legal experts, without the legal input, the newsrooms, the content creators, etc., are in the blind because they do not have the expertise. This is where we rely on you. This is where the legal division of the ABU and those of you present here are the key players for us. The legal committee plays a foundational role in safeguarding our future, not only the future of individuals or individuals in newsrooms, but for broadcasters. On behalf of the Secretary General and the entire ABU leadership, I want to express my deepest gratitude to the IPLC chair, the committee, the members, Dr. Sima at the ABU Secretariat in Malaysia, and everyone involved in ensuring that the content we make on a daily basis is protected. We're not there 100%, but probably we could say that we are getting there. Thank you very much for your hard work that you put in. It is time we all got together and provided that shield that protects our creative heritage and the blueprint that ensures our digital future remains ours and not that of third-party creators. Once again, thank you very much to RRI. Thank you very much to all our committee members that are present here. And I wish all of you a highly productive, insightful, and impactful conference. Thank you very much.
Thank you very much for the welcoming remarks, Mr. Indra Singh. And now, last but not least, let's give a warm welcome to the chairperson of ABU IPLC, Mr. Haruyuki Ichinohashi. The stage is yours.
Okay, thank you very much, and a very good morning to all of you. Mr. Mistam, Program Production Director of RRI, Mr. Anwar Mujahid, Adi Trisnanto, and Mr. Boogie Haidiat, Mr. Indra Singh, ABU Director of News, distinguished speakers and guests, international delegates representing members of the ABU, our esteemed RRI colleagues, and ABU officials. First of all, I would like to thank our distinguished RRI colleagues for hosting this valuable opportunity. We very much appreciate your kind and thoughtful cooperation and support. As the digital technology progresses, our content becomes ever richer, and the technologies we use to deliver it also diversify, both in broadcasting and via the internet. Needless to say, the ways of producing content are improving too. Conversely, the technological developments and the emergence of AI in particular also raise various legal issues, including in the fields of copyright and ethics. In such an era, the broadcaster's role of serving the public has become more important than ever. As trusted media organizations and content producers, we are expected to provide our audiences with appropriate guidance by delivering accurate, fair, and trustworthy information in a world of deepfakes, misinformation, filter bubbles, and the challenges of the attention economy. In producing and delivering information and contents, we also must, of course, respect people's rights. We can't earn or retain public trust by impairing or impeding people's rights. Considering all of this, I am sure you agree that awareness of and respect for intellectual property and other legal matters are key for every broadcasting operation, including the legal and ethical matters for content production, which is this committee's theme. Our host organization, RLI, has given deep thought to the theme and topics of this IPLC conference meeting, which is AI, copyright, royalties, and in digital economy. It is indeed a timely and well-chosen topic in view of the ongoing trends and issues which face us. I am certain today's conference and tomorrow's meeting will provide invaluable opportunities for us all to learn about and share recent trends, insights, expertise, and opinions with each other. Lastly, and most importantly, I am hoping for two extremely fruitful and productive days ahead. Thank you very much.
Yeah. Ichino Hashi-san, could you please remain on the stage, because I would like to now invite the Director of Program and Production of RRI, Bapak Mistam, to come on to the stage, because Mr. Ichino Hashi would like to give a souvenir to Pak Mistam. Photographers, please go to the front of the stage to Okay, I would like to invite the photographers to take picture of this moment. Please, everybody. Okay. Please give big round of applause to Pak Mistam and also Mr. Ichino Hashi. And now I would like to also invite Mr. Indra Singh to join us to the stage for a commemorative photo. Okay, please take the picture in 3, 2, 1. Okay, thank you very much. Please make a big round of applause for everyone here. And thank you, Pak Mistam, Mr. Indra Singh, and also Mr. Ichino Hashi. Please be seated again. Okay, and now we would like to take a reverse photo here. I would like to invite the photographers to go to the stage. And all the participants here, distinguished guests, please give us your best angle for our photographers here. Okay, should everybody stand up? Okay, everybody, please stand up. Including the ones in the back, please stand up and join us in the picture. Okay, which is the main camera? Okay, okay, in the count of three, please. 3, 2, 1. One more time, perhaps another style? No? The same one? Okay, thank you very much. Okay, thank you very much, everybody. Thank you very much, everyone. Okay, ladies and gentlemen, that is the opening for the conference. And please be seated because the first session will begin. So I would like to give the mic to Zima, the host of ABU.
Good morning, everyone. Welcome all of you to the 32nd ABU IPLC. We appreciate all international participants and local participants. I understand that this has been a slightly busy morning for some of you, as some of you were stuck in traffic. Actually, one of the speakers for the first session is on his way, so if we can just wait for 5 more minutes, and then we will start with the first session. And the moderator for the first session is Ms. Minoli Ranasinghe. She is the Director of Copyright for Capital Maharaja Group, a very well-respected lawyer and an old friend. And she will take it from there. But we will just wait for 5 minutes so that the speaker is here.
Good morning, everyone. I think our missing speaker is here at the moment, so we can start the first session. First session is on AI and copyright framework. And I would like to welcome to the stage our speakers of the first session, Mr. Ahmad Iqbal Taufik. He is the legal analyst, Copyright Directorate General of Intellectual Property, Ministry of Law, the Republic of Indonesia. And then we have Mr. Desmond Chan, Deputy General Manager, Legal and International Operations, TVB, Hong Kong, China. And of course, then we have IPLC Chairperson, Mr. Haruyuki Ichinohashi. And last but not least, I think we will have Ms. Huangjuang Peng joining us online. She is a PhD candidate of the Singapore Management University. Good morning, everyone. Okay, I would like to welcome Mr. Ahmad Iqbal Taufik to take the podium for your presentation.
First, okay. Okay, thank you very much.
His presentation will be on adapting the national copyright legal framework in the era of generative AI, an Indonesian perspective.
Okay, good morning. Selamat pagi. First of all, I want to say thank you very much for the invitation. But before I begin, I'm going to say apology for my Director General, Mr. Herman Siregar, because he can't attend this meeting because he has another meeting, and kindly asked me to deliver this address on his behalf. For that, I'm going to I'm going to share you about the Indonesian perspective about we call adapting the national corporate legal framework in the era of generative artificial intelligence in Indonesian perspective, because this is very, very unique, complex, and it disturbing all of kind of creation in not in Indonesia but in all the world, and that's why we are now make a revision our new copyright copyright law 2028 2014, and we are now revising and want to pursue and to the strengthen of the copyright, especially dealing with the artificial intelligence. Next. Oh, sorry. This one. Can it move? This one? Yeah, I cannot. Okay. Stuck. Okay. Wait. How many minutes that? 50, okay. It's stuck here. Can't move. I'm sorry, steady. Okay. We all agree that the generative AI disrupt of the entire creative value chain. First, that if we have a works that before we produce something work that we call it an input before it, we have the creation like music, books, and other, maybe poem, maybe like other kind of works that are collecting by the data, by via scraping and dataset replication. And the first thing is who gave the permission, because the copyright is it's formed by the declarative system. So we have to declare our works, and we have to give permission, and the other people that want to use our creation, our works, they have to ask our permission to use it. And then for the AI, who gave them the permission? And then after that, it used for the training, like learn the pattern, something like that. And also and the output, and we cannot make sure is it who's the creator and who's the liable. I mean, the insight is the core legal issue is not just who owns the output, but the how human works are ingested and utilized within the system. Okay. 30. Okay. This is assessing the three assumptions embedded in our corporate existing law. The first is it the protected word that it can contain a substantially generated AI and meet the legal requirement of being the distinct part of our personal creation of a human, because we still pretend that human is a creator. AI is just for the assist. It's not for the subject of the law. And the second is the input. Is the training permitted? Does the user copyrighted works to train AI fall under the existing limitation and exception, or does it require a license? And then the main thing is the who get paid and how. Can system design for human scale used to identify and compensate creators at the film at velocity driven by an AI. And the summary is the existing laws provide a foundation, granting automatic rights to human creators, but lack explicit norm for AI training data in human contribution threshold and dataset transparency. Next. Oh, okay. What is it? Okay. And Indonesia still aims to protect human creativity without stifling the innovation, creator protection, defending moral and economic rights, and ensuring attribution and fair remuneration. But we cannot divide the technology invention also. We have to supporting research and education, and providing legal certainty for the developers to drive creative industry growth and digital competitiveness. The corporate super block is the human at center. Generative AI is a machine-based system. It's just as a tool. AI has no legal personality, creative will, and moral rights. Corporate protects human creativity, not pure computation. And the goal is the proportional and equitable distribution of benefit, risk, and responsibilities across the entire creative of value chain. Okay. We have the degree of the human control determine eligibility for the protection. First is an AI-assisted high human control. Human control, the creative conception, expressive choice, curation, editing, and final expression is fully protected because there's a mainly contribution of the human. And the second is human AI, shared contribution. Subset AI contribution, but a human select, arrange, and refine the output. It's still isolated by case. But now we're talking about AI generated, minimal human control. So output lacks sufficient human creative contribution. Let's say we are like say we use application like Gemini or Cloud or something else. We just put the prompt, simple prompt, and then they create journal, they create books, something else. But we don't contribute more in that creation. I think it's not automatically protected because we just, they use fully controlled by the AI. So the simple prompt is not the main point. We have to make a very, very complex prompt. We have to ensure that we as a human control the system. We have to make a journal or something. We have to take out from the AI. We check again. We make sure is compatible if you make a regulation with Indonesia regulation or national regulation. We control and make a very, very, what I call it, very, very, high contribution in that works. Because of what? Because the output that reproduces substantial part of the previous work creates potential legal liability for the user. A prompt alone is rarely enough to establish copyrights. We have to make sure that our prompt is very, very complex, and we have to make sure that we contribute more to create that works. Okay, and there's one more, the autonomous AI. It's kind of protected by the law because it's autonomous. It can think by itself. And we have 4-step tests distinguish an AI-assisted authorship from mere machine output. But first is, we have to make sure this is originality for the human. It's original draft. Did the human independently compose the prompt of creative draft? And the second is the editing contribution. Did the human edit, arrange, or refine the AI output? And the second is that the work is legally protected by the law? We have to make sure, is it music, book, or other creation, or other works? Is it related with the science, art, or literature? It depends on the national law of itself. And then the distinct character. Does the work exhibit a personal and distinct character attributely to the human control? Because it's, corporate is originally produced by human itself. It is for character are made, the work is classified and assisted, and the human contributor is recognized as the legal author. Okay, the AI trait extends beyond the economic to the identify reputation and authenticity. The first is the omission of the character attribution itself, and the second is alteration, the work that damage reputation. We have to make sure that the works, if we can't, is it damage the reputation of the author itself. So we can make sure that if we take or we get the work like music or book, is it fully permitted by the author or not? And the problem is that now we're facing about the voice and facial cloning, or in the US we call it the Elvis Act, the sound, the voice, the style of the authors. That's why in our revision we put them as our main substance in AI that we have to make sure it's protected or not in law. And also the synthetic falsehood and defects. The short regulated defense is like the standard attribution and integrity rights, mandating explicit consent for the use of voice or an image. And that also the point is mandatory labeling of AI. If you are using AI, you have to make sure, you have to label what kind of AI. If you use Gemini, like this one, I'm using Notebook LM. I'm using the presentation. And also the first thing is the establishing the right to the takedown, deletion, and restoration of the work from the authors. And then the work used as fuel cannot remain as a breadcrumbs. I mean, the first is we have to make sure the source of the legality was access is underlying works obtained illegal. And the second is traceability. We have to has duplication occurred within data set and can be documented. And also the reservation of the rights. That the right holders have the functional ability to opt out or refuse the usage. And the first thing is very important for us, is commercial remuneration. Does the commercial use of the training data mandate licensing or not? Because of the transparency in the fundamental prerequisite of the all licensing and remuneration. Okay, and we are talking about that text and data mining, and is it one of the main point of our revision? Then the first is there's any limitation for the research, education, but for the commercial use, we have to restrict the transparency of data source. We have to output mechanism and requires individual or collective licensing and the mandate fair out and auditable remuneration. A single overly broad example of TDM would effectively transfer economic value from creators and directly to a developer. I mean, we have a limitation for the using the copyright without permission. Education, research, and also for the news or something, as long they make sure they announce who's the authors. Okay, oh, sorry. Okay, now is the legal structure first we can use for in our regulation. We can use direct licensing if the B2B used for highly and identifiable premium catalogs, requires direct and per rights holder license, and also we can use the collective licensing if it's for the mass permission, like in music. And the next session is Mr. Marcel, my brother, will explain to you about the mass permission, because we cannot ask the permission if you are make a concert. You have and you have to sing maybe 20 songs. We have to ask the permission one by one. It's wasting time. So we use the collective licensing, and also with the collective for the books and other kind of works that use mass permission and scraping, distributed through the CMOs, and the structure of on basic like music, book, press, visual art, and audiovisual. And the accountability must follow the proximity of a control source to the risk. The first is, this is the distribution level, responsible for handling copyright report, takedown and content restriction, and responsible transparency or AI declarations and service security, and also responsible for handling copyright reports. And then also for the core is responsible for the dataset legality, system design, and algorithmic risk mitigation. Because the principle, the end user must not bear the sole burden for the risks that they originate from the flow, system design, and illegal data set scraping. Because in Indonesian law, if there's someone use the work without permission, the authors can sue them in criminal or in our police, or we sue them in the court for the against the law for using without permission. So the regulation is refers is we have to identify the works. We have to make a standardized metadata, and universal identifier codes embedded in the content. And the second, we have to make sure it's with the right data, and user tracking, and the fourth is payment and audit. So make sure it's distributed well and accurate royalty in music, also and maybe in the books. Okay, and this one, we have to make sure we have a phased roadmap for adaptation, the first guidelines, legislation, and infrastructure. The first is we have to make immediate action. We have to make guidelines. In Indonesia, you have the draft of the regulation for the roadmap of AI. Is we have a ministry that related with AI from the Ministry of Digital. We have they are part of AI artificial units, so they have to make the guidelines, And also we have to initiate multi-sectoral dialogues. And also not for stakeholder, we have to like the platform and also we have to make a legal revision, not only for copyrights, we also another regulation that related with AI, formalize the rules of TDM, data set and mention redeemable opt-out, and the mandate of commercial use licensing. And the last one is ecosystem maturity. Deploy comprehensive digital corporate infrastructure, establish auditable AI royalty machines, mechanism, and achieve cross-border data interoperability with an Asian or global. And the 5 policy pillars from Indonesia corporate blueprint, the first is center of human protection. The second is the mandate of data transparency. The third is build commercial licensing using now direct or collective management system. Distribute risk proportionality, and the strengthened digital infrastructure. So maybe we can communicate with our Indonesia as the Ministry of Digital. And also because of the future of copyright is not choosing between human and technology. It is ensuring technology works for human creativity, justice, and prosperity. And the second is now we after inviting ABU collaboration. The first is joint standard developing shared best practice for labeling and attributing AI-assisted broadcast content. And then data interoperability, the technical dialogues, discussion, and also shared capacity building, joint training between the nation and coordination multilateral voice. So we have to make sure that we have in same concept, same mind, to make sure that our copyright works and it's not protected by law, and AI is just as a tools. And thank you. Thank you very much. And I'll give back to the moderator. Thank you.
Thank you, Taufik. Next, we have Mr. Desmond Chan speaking on the topic of AI impact on copyright law, media law perspective.
Good morning, everyone. It's my pleasure to join you at the ABU IPLC Conference 2026. Now, my topic today is AI impact on the copyright law from the Hong Kong and US perspective. I promise it's not going to be a heavy law lecture because many of you are broadcasters or content creators. I will focus on one practical question. If your company spends money creating AI content, can you own it, exploit it, and stop others copying it? Now, let's begin with a short AI video created by TVB. As you watch it, please think like a content owner, not only as a viewer. Ask yourself, who owns this?
你覺得曾之悠點啊？
咩點啊？
唔知點解，我呢排成日都諗起佢。
Sorry 啊，遲咗少少。
唔緊要，嗌嘢食先啦。
鄭柏賢，你係咪落緊單啊？幫我加個牛肉芝士 burger。IG 好多人都話好食㗎。
你都幾識食喎？
呢啲嘢梗係上網睇定㗎啦。 好中意食嘅朱古力 pancake 啊！
你都幾細心喎。
網上啲人話好味，咁咪叫你 share 咯。
呢份嚟嘅。點解會咁嘅？
Now, okay, in this video, almost everything was generated by AI. The script, actors, music, lyrics, singer, visual scenes, and settings. The only exception was the spoken dialogue. TVB used real human performers to voice the dialogue because AI could not fully capture the human touch. Now, suppose TVB spent $1 million making this AI film. 5 years later, someone copies the whole film and puts it on another platform. Can TVB stop them? This is the question I want to answer today. Okay, now let me give you the short answer first. In Hong Kong, a pure AI-generated film is probably protected by copyright because Hong Kong has special rules for computer-generated works. In the United States, the answer is very different. A pure AI-generated film is generally not protected if there's no sufficient human authorship. So the same film made with the same AI tool may have different copyright results in different countries. That is why this issue is not just legal theory. It affects investment, licensing, distribution, and enforcement. For broadcasters, the important questions are, who owns the copyright? How long does it last? And will it remain protected when the content is distributed around the world? Now, before we answer these questions, let us look at the difference between AI-assisted work and AI-generated works. AI-assisted work means the human remains the creative brain. AI helps, but AI does not take over the creative role. For example, a writer writes a script and uses AI to improve the English. A director films a firefighting scene, and a technician uses AI to add frames and exposure effects in post-production. AI helps enhance the scene, but the creative work still comes mainly from humans. Now, in these examples, AI is a tool. The human is still making the creative decisions. Put simply, human first, AI second. The human is the chef, and the AI is the kitchen equipment. AI-generated work is different. The human gives instructions, but AI creates the expression. For example, the user types, generates a TV drama, writes a theme song, creates a virtual actor, or produces an opening sequence. The AI then decides the words, image, melody, look, and feel. So this matters because copyright protects expressions, but not ideas. If the human only gives a broad ideas, but AI creates the detailed expression, then the copyright analysis becomes more difficult. Now, let's look at Hong Kong. Many scholars argue that copyright exists to protect only human creativity. Therefore, they believe AI-assisted works may be protected by copyright because humans remain the creators, while AI-generated works should not be protected because the creative work is done by a machine. Now, that view is understandable, and it is broadly consistent with the current position in the United States. But it is not the position under Hong Kong law. In fact, Hong Kong has recognized and protected computer-generated works for almost 30 years. These provisions were adopted from the UK model and have existed since long before ChatGPT, Midjourney, or other modern AI tools appeared. The interesting point is that a computer-generated work is defined as a work generated by a computer in circumstances where there's no human author. So in other words, the Hong Kong legislation already contemplated works being created without a human author. So the Hong Kong law does not simply say, no human author, therefore no copyright. Instead, it asks a different question. If there's no human author who made the arrangements necessary for the work to be created, the law then deems that person to be the author of the work. Now, to keep things simple, I will call that person the arranger. Think of the arranger as the person who is mainly responsible for making the creation process happen. This leads to a surprising result. Under Hong Kong law, a pure AI-generated work may still enjoy copyright protection, so it would not be accurate to say that only AI-assisted works can be protected. Unlike the US approach, Hong Kong law has had a framework for protecting certain non-human created works for many years. Of course, that does not mean all the problems disappear. The next question is, who is the arranger? Is it the company that built the AI model, like OpenAI? The company operating the AI platform, like Microsoft Copilot? The producer writing the prompts, or the broadcaster commissioning the work? Hong Kong law does not yet give a very clear answer on this. The answer will depend on the facts of each case. For Hong Kong broadcasters, the risk may be less about whether copyrights exist and more about who owns it. The United States takes a very different approach. The starting point there is human authorship. US copyright law protects human creativity, and US copyright legislation does not contain a computer-generated works provision similar to Hong Kong's. So in the US, if there's no sufficient human author, the work may not be protected at all. The leading example is Tyler and Permuter. Dr. Steven Tyler developed an AI tool that creates an image. He submitted this image for copyright registration and lists the AI tool as the sole author. The application was rejected, and Dr. Tyler brought the matter to court. The Court of Appeals decided that the works produced autonomously by AI are not eligible for copyright protection because they lack sufficient human authorship. Another useful example relates to a comic book called Saria of the Dawn. The storyline was written by a human, but the images were produced using the AI tool Midjourney. The US Copyright Office allowed protection for the human written text, but not for the AI-generated images. Now, we can summarize the legal difference in one sentence. Hong Kong asks, who is the arranger? The United States asks, where's the human author? For broadcasters distributing content internationally, that difference matters. So what does this mean commercially? It means AI-assisted and AI-generated works may both be useful, but they do not carry exactly the same legal package. For copyright subsistence in Hong Kong, AI-assisted works are protected in the normal way if the user requirements are satisfied. AI-generated works may also be protected, but through the computer-generated works provisions. For authorship, AI-assisted works are easier. The author may be the writer, director, composer, designer, or another human creator. For AI-generated words, we need to identify the arranger, namely the person making the necessary arrangements. For moral rights, the difference is important. AI words may carry moral rights, such as, AI-assisted words may carry moral rights, such as attribution and integrity rights, subject to exceptions and waiver. Computer-generated words generally do not enjoy these moral rights. For duration, the difference is also important. For literary, dramatic, musical, and artistic works, such as scripts, lyrics, music, and artwork, AI-assisted works generally last for the life of the human author plus 50 years. AI-generated works last for 50 years, from the end of the calendar year in which the work was made. For films, a normal human-created or human-assisted film lasts until 50 years after the death of the last survivor among the principal director, screenplay author, dialogue author, and composer. But if a film is purely AI-generated and there's no such human contributor, the copyright lasts for 50 years, from the end of the calendar year in which the film was made. So the message is not that AI-generated words are useless or unprotected in Hong Kong. The better message is this: Hong Kong may protect both, but the legal instances are different. Authorship, moral rights, duration, ownership certainty, and international enforceability. So what should broadcasters do? My suggested best practice is simple. As far as possible, structure projects as human-led and AI-assisted, rather than purely AI-generated. This does not mean AI-generated works are worthless. In Hong Kong, they may still be protected. But human-led AI-assisted works are usually more robust commercially. For example, longer protection for many underlying works, possible moral rights protection, easier authorship and analysis, and a stronger protection in the United States. Most importantly, check the terms and conditions of AI tools. Use tools that do not take away your copyright or require you to share your rights with them. And equally important, keep records. Keep prompt history, prompt revisions, draft scripts, storyboards, editing decisions, producer comments, approval records, and version history. These records help show how much humans contribute to the creation process. The more human involvement there is, the stronger the argument that the work is AI-assisted rather than purely AI-generated. The same practical advice appears or applies in both Hong Kong and the United States. So let me close with the key message. AI can generate scripts, images, songs, voices, and even dramatic scenes. But copyright law still looks for a legally recognizable creator. Hong Kong is relatively flexible because it recognizes computer-generated works. The United States is more demanding because it requires human authorship. For broadcasters, the safest strategy is to keep humans clearly in control. Use AI as a powerful assistant and keep good records of the human control. So in one sentence, use AI broadly, but document human creativity carefully. Thank you very much.
Thank you, Desmond. Ladies and gents, I'm sure you have questions to ask from our speakers. We will be having our Q&A at the end of the session. Now I invite Haruyuki Ichinohashi, IPLC chairperson, to speak on Japan Copyright Office perspective on AI training and copyright use.
Once again, very good morning, everyone. I wonder if I can use the slide. No. There you go. Okay, actually, I moved the slide too much. Thank you. Okay, so today I'm going to talk about the use of AI and related issues in the field of copyright from Japanese perspectives. My presentation actually may duplicate with the other speakers' presentations, but it probably tells you that, that kind of topic is sort of universally common. And if you find other aspects sort of unique, maybe it could be a kind of a locally unique, I suppose. So, okay. So AI technology, as you know, is progressing quickly, and use of AI is also spreading out rapidly. As we are aware, there are both merits and possible issues to the use of AI. For example, AI can improve productivity and work efficiency. On the other hand, the issues include the uses of confidential information and personal information, and of course, copyright infringement can also be an issue. So now we see the three phases of AI on this slide. First, AI model developers develop and train AI models, and copyrighted works may be used in this training. This is called the training phase. Second, users use the AI model provided by the AI provider to produce output. This is the utilization phase. And third, as a result of this utilization, generative AI is created as an output. This is the output phase. And let's see, look at this phase by phase. Okay, first, the training phase. Here, the copyrighted works may be used to train AI models. I must remind you of the core premise that the user needs to obtain authorization from the copyright holder in order to use a copyrighted work. This is so-called copyright clearance. In this regard, the initial question is whether or not copyrighted works are being used for AI model training. If yes, copyright clearance arises in principle. However, some jurisdictions may provide limitations and exceptions that can be applicable to the use of copyrighted works in AI model training. And if such a limitation and exception exists, and if the way a particular case of AI model training uses a copyrighted work corresponds to the criteria for that limitation or exception, no copyright clearance is necessary. Also, as a matter of choice for the copyright holder, some jurisdictions may also provide an opt-out that allows the copyright holder to exclude a copyrighted work. Okay, second, the utilization phase. Here, the user is using the AI model and the output will be created. The question here is, the mere action of using AI to produce an output can constitute a copyright infringement. How about using an output which is so-called a generative AI? Also, are there any limitation exceptions that can be applied here to the use of AI and its output? And third, we have the copyrightability of the output. The question here is that seeing as the output is created through use of AI model, can this output itself be a copyrighted work? Is it human created? Or is it an output, a work which expresses or employs human emotions or creativity? I understand these issues are under discussion in a number of countries. And in Japan, a committee appointed by Japan's Agency for Cultural Affairs has discussed and published a general understanding regarding these questions. The committee noted that its conclusions represent just one way of thinking and are subject to change in the future. Also, that they are not legally binding or do not constitute specific legal opinions. So please keep these things in mind. Regarding the training phase, the copyright law of Japan provides an exception for the use of copyrighted work in the case where the work is not used for enjoyment of the thoughts or sentiments expressed in it. This is termed exploitation of non-enjoyment purposes and includes both AI development and other forms of data analysis. In general, a user needs to obtain authorization from the copyright holder to use a copyrighted work, but when this exception is applied, the copyrighted work can be used without the copyright holder's authorization. However, this exception is not applicable in cases where enjoyment is the purpose, or even when it is not the main purpose, but enjoyment is involved to extent. Also, there are certain other conditions. For example, it doesn't apply in cases where use would unreasonably prejudice the interests of the author or copyright holders. Second, the utilization phase. The committee's general understanding states, if an AI-generated image or any other creation is found to have a similarity with dependence on an existing copyrighted work and no copyright exception applies, it shall be considered as a copyright infringement. This principle is the same as for existing copyrighted works, and there are no new interpretations. So the question of the copyright does again depend on how the AI model is used and how the output is created and used. In the Japanese copyright framework, similarity and dependence will be a key to consider whether an output needs a copyright clearance as a copyrighted work. And third, output and copyrightability. Under Japan's copyright framework, the term copyrighted work refers to a creatively produced expression of thoughts or sentiments that falls within the literally academic, artistic, or musical domain. On this basis, the committee's general understanding states material autonomously generated by AI will not be considered as a copyrighted work. Conversely, if a person uses AI as a tool to express thoughts or sentiments creatively, that material will be considered as a copyrighted work, and the AI user as the author as a copyright holder. So you can keep these things in mind and when you use the copyrighted work in Japan. And of course, this is the only case of Japan. So for example, Desmond introduced in the cases of Hong Kong and United States, and they are different. So the discussions and legislations are subject to individual countries. And in addition to these three phases, there are some other perspectives now under discussion. And, oh, sorry, I missed it. But anyway, the topic can be, for example, transparency, accountability, and traceability will be a keys as well. And now, I am going to talk about some possible measures for mitigating risks attached to the use of AI. As I explained, AI model developers could be using copyrighted works when training AI model. Also, copyright clearances are necessary except when any specific exceptions or limitations are applicable to the use of copyrighted works for AI model training. Keep these things in mind, what measures can mitigate the risks of copyright infringements, and what ought an AI user bear in mind when using an AI service. And first, when using the AI model, the user should assess the risks by checking how the AI model developer used copyrighted works in AI model development. And second, when using the AI model, the user may mitigate the risks by learning how the AI system provider provides its AI service. The points are, for example, whether the AI system providers used any technical measures to prevent intellectual property infringements, and whether the AI providers have any policies in place with regard to copyright infringement, etc. And keeping these things in mind, there are several perspectives that a user like us, broadcasters, ought to consider when using an AI model or output. For example, as I explained, has the AI model developer obtained copyright clearances for AI model training? If not, have copyrighted works been used for AI model training within the framework of limitations and exceptions? Are there any technical measures to prevent infringements? The question here is whether the AI model that you utilize makes proper use of copyrighted works. And in addition to it, does AI provider disclose information about the database or works it used in AI training? Does the AI provider make its terms of services public? And as I told you, transparency and accountability are also important as well. And these are all the matters on the policy of each AI service provider. And now, how about the policy of the user? The first question here is, how has an AI output been created and used by the user? For example, does the user's organization provide staff training and lay down rules for AI use? Proper training and uses that observe the rules can mitigate the risks that end in copyright infringements. Also, does the use of AI output fall within a framework or limitations and exceptions, or does it require copyright clearances for that use? It is obviously safer to consider this point before the output is used by the users. And what about other possibility of copyright infringements? For example, is an AI output similar to any existing copyrighted works? Users can check other copyrighted works on the internet, for example, before they use it. And users are also advised to record the prompt they have used for the purpose of traceability. These are the perspectives that can mitigate copyright infringement risks when users like us select and use an AI model and then carry on to use an AI output. So this concludes my presentation on copyright perspectives relating to the use of AI. These discussions on use of AI are taking place all over the world, and I have endeavored here to mention some of the issues. Well, anyway, please ignore the slide now because I have showed all the slides. So, but anyway, with these things in mind, there are aspects that are not clear yet or maybe subject to change, and in many cases, interpretation looks like progressing on a case-by-case basis, depending on how AI model is used and how the output is created and used. In any case, it is certain that we do need to comply with respect the copyright frameworks when we use copyrighted works to create and use content. We do need to respect compliance, and content production and exploitation can't be cut off from the copyright frameworks. This remains the same in using AI too. Thank you very much.
Thank you, Haru. Now we move on to our final speaker, who will be joining us online.
Hello, can you hear me now?
Yes, yes, we can hear you.
Okay, is the
Sarah.
slides there? Yeah?
Yes.
All right. Good morning, everyone. Greetings from Singapore. I wish I could be with you in person, but I'm also very pleased to join you online today. Given the topic of this session, perhaps appearing digitally is quite appropriate. Today, I will speak about generative AI output, copyrightability, and authorship challenges. The copyright debate around generative AI has two distinct sides. The input side concerns the use of copyrighted works for AI training. This includes remuneration as well as copyright exceptions such as fair use and text and data mining. The output side raises a different set of questions. is an AI-generated output copyrightable? Who may be recognized as its author and owner? And does the output infringe copyright in an earlier work? These questions are related but legally distinct. My presentation today will focus on output side, particularly copyrightability and authorship. Why does this matter? Here are two examples. In 2017, Xiao Ai's published a Chinese language poetry collection, and in next year, in 2018, an AI-generated portrait was sold at auction for more than $400,000 US. Both examples actually came before ChatGPT and show that AI was already being used in the creative industries and generating commercial value. As AI-generated content becomes more widely used, individuals and organizations need to know whether it is protected by copyright, who can claim the rights, and how they can prove their claim. These questions begin with authorship, because authorship helps determine whether copyright exists, and if it does, who initially owns the right. The prevailing legal position is that an author must be human. Some scholars have proposed to regularize AI authorship, particularly for purpose of attribution and transparency. But this remains largely a theoretical proposal and would require significant legislative reform. So under current law, the practical question is usually not whether the AI system can be the author, but whether the human user was contributed enough to qualify as the author. The first example is the Jason Allen case. Allen sought to register an image he had created using Midjourney. He stated that he had entered at least 624 times before arriving at the initial image. He then edited it and enhanced the image. The US Copyright Office asked him to exclude the AI-generated element from his copyright claim. He declined, and then the registration was refused. In 2023, the review board affirmed that the refusal, and finding the Midjourney generated element lacked human authorship. So the lesson from Allen case is not that using AI prevent copyright protection. In 2025, the Copyright Office report makes several key points. First, the use of an AI tool to assist rather than stand in for human creativity does not affect the availability of copyright protection. Second, copyright protects the original expression in a work created by a human author, even if the work also includes AI-generated material. Third, copyright does not extend to purely AI-generated material. As a speaker mentioned before, this is different from Hong Kong. Or material whether there is insufficient human control over the expressive elements. Moreover, the report emphasized that whether human contribution to AI-generated output are sufficient to constitute authorship must be analyzed on a case-by-case basis. It also states that based on current available technology, prompts do not provide sufficient control. At the same time, copyright may protect the human authored expression that remains perceptible in the output. It may also protect the creative selection, coordination, or arrangement of material, as well as creative modification made to an AI-generated output. So the key question is not simply how much work the user performed, but whether identifiable human authored expression can be found in the resulting work. Yeah, we just now also heard about this case. There are some overlap. The Taylor case gives a clear example of a human authorship requirement. Like Allen, who claimed, unlike Allen, who claimed that his own extensive involvement supported authorship, Tyler actually deliberately identify the AI system itself as a sole author and himself as a copyright owner. The US Copyright Office refused registration because the work lacked human authorship. The district court upheld that refusal, describing human authorship as a bedrock requirement of copyright. The DC Circuit later affirmed, holding that the copyrightable works must be authored in the first instance by a human being. The key takeaway is that under current US copyright law, an AI system cannot itself be recognized as the author. Turning to China, the approach is also human-centered, but the assessment of human contribution could be slightly different. This is an example Li Binliu. In that case, Mr. Li used stable diffusion to create an image and posted it on the social media. And Ms. Liu later used the image without permission and removed the Li's watermark. The Beijing Intellect Court found that the image fell within the field of art and was expressed in a certain form. It then examined the originality and intellectual contribution and ultimately held that the image qualified for copyright protection. The court found that the Li's selection and arrangement of prompt, parameter settings, revisions, and the final image selection and reflect his intellectual investment, aesthetic choices, and personal judgment. It therefore treats stable diffusion as a creative tool rather than an author, and recognizes Li as a human author of this image. Actually, this case was attract criticism from some scholars, and the ruling remains uncontroversial. But this decision does not mean that every AI-generated output will be automatically protected in Chinese law. Here is another example, Feng v. Dongshan. This is, in this case, Ms. Feng used Midjourney to generate a series of images showing transparent chairs shaped like butterfly wings. She later alerted that the designs had been copied. However, Feng had not provided sufficient record to show her creative contribution to the generation process. She also acknowledged that because Midjourney's output involved an element of randomness, so the same prompt could not produce the same image. Eventually, the court held that he had failed to establish original human authorship and that the AI-generated image did not qualify for copyright protection. So the contrast is not simply copyright protection in Li Binliu and no copyright protection in Feng. The deeper difference lies whether the claimant could demonstrate or prove the sufficiently identifiable human contribution. Let's now turn to Singapore. Although in Singapore, there's no reported case that directly address copyright protection for generative AI output. The emergent position can be seen in existing doctrine, public guidance, and a recent reform report. This including the 2024 IPLC SMU Landscape Report, which I also co-authored. And also the IPLC 2025 Public Guidance on AI Generated Content, and the Singapore Academy of Law 2026 report. So Singapore's current position can be summarized in 3 points. First, an author work must have a human author. Second, there must be sufficient engagement of the human intellect. That engagement must be sufficiently connected to the expressive element of the output. Third, significant creative or editorial control may help demonstrate that connection. So where the connection is sufficient remains a question of fact and degree. This brings us to a central unresolved question: how much and what kind of human contribution is sufficient to establish authorship? At present, there's no fixed or uniform standard. Actually, currently, I'm writing a paper on this topic. So the assessment remains case-specific. The uncertainty also shows why the familiar distinction between AI-assisted and AI-generated works may be too simplistic. In practice, human and AI contribution are often entwined, and the degree of AI involvement may vary at different stages of the creative process. As a result, the line between the two can become increasingly blurred. Rather than focus on output into one of two categories, it may be more useful to view human contribution along a spectrum or degree. The law should therefore look beyond the labels and examine the actual creative process. The key issue is not the label itself, but whether there is sufficient human author expression in the final output. Having compared the United States, China, and Singapore, we can see both convergence and divergence. All three jurisdictions remain human-centered and do not recognize AI itself as the author. They differ, however, in how they assess whether human contribution is sufficient to establish authorship. Because AI-generated content circulates across borders, this difference creates legal uncertainty, greater international coordination, and where possible, greater convergence in the criteria used to assess human contribution would improve legal predictability. So what does this mean in practice? Document the human contribution. First, preserve the input and the process. Save the prompt, platform, and the model details, and the relevant selling state, and so on. Second, record a creative choice and edits. So you can make a note of particular output selected, rejected, or revised, or combined, what specific human changes were made. Third, retain both the original AI output and the final version. The aim is not simply to show how much time or effort was spent, it's also to establish a clear and traceable connection between the human creative contribution and the final work. Of course, documentation does not guarantee copyright protection, but without it, proving human authorship may become considerably more difficult. To conclude, there are three key takeaways. First, the use of AI does not, by itself, prevent copyright protection. Second, AI systems are not currently recognized as authors. So third, the difficult question is not whether there was human involvement, but whether the human contribution was sufficient to establish authorship. Thank you very much for your attention, and I think the Q&A part will be the most human part for this presentation. I look forward to our discussion.
All right, ladies and gents, now we move to the Q&A section. Do we have questions from the audience? I'm sure our speakers would be happy to answer. Any questions for our speakers? Okay, I'll start, I guess. Taufik, you went first, so I'll start with you. Okay, so we have to agree that legal fraternity is basically playing catch up at the moment because technology is moving at a much faster pace. And we also have to accept that most of the Gen AI systems that the broadcasters or any of the users are using right now, they're probably trained on content without authorization, material obtained without authorization. So can you tell me in Indonesia whether the CMO infrastructure is evolving at a pace to address this? How are you all looking at this?
Okay, thank you very much. Actually, the CMO Indonesia is, not only, I mean, in music, not for the CMO, other kind of works. Yeah, I mean, the CMO in Indonesia is just related with music first, and then we are going to have another CMOs in other. We have CMOs for books and literature. We call PRCI, and related with IFRO also. But it's still not. I mean, can't take the how to collect, and because we have to. They have to build the mechanism, the mechanism royalty, the mechanism how can they take the royalty from the platform, or because it's not simple. So that's why in our revision of corporate bill, we make sure the first is we have to protect the works itself. The second, we have to make sure the ecosystem, the mechanism is comply with international rules also. And not only for music, we have the books, and for the artist restaurant also. And is the related with AI, they make sure that the compensation is paid well. But we have to make sure is it because in our existing law is not really compromised with that. I mean it's not built in because it's it's from 2014. It's a long time ago. It's not dealing with the AI, so we have to revise that. And it is the initiative or people of our DPR. So, but we have to make sure that the substance of the platform, the mechanism of the royalty, and like my PPTs. So because it's not really simple, it's complex. We have to make sure like broadcasting, just like journalistic. So we have to make sure that all the works, all the news, or some they use for the training data, they have to pay. We have to have the permission from the authors. So it's a hard work from Indonesia to have this situation. So we must make sure that our revision is to strengthen the substance of how we are dealing with the platform, like Google, like like other kind of platform, like music also. So we have to make sure that we cannot make a same mechanism with music, because the journalistic is different with music, and from the books also. But we have to make sure it's in our copyright bills. The first is that everyone that use the work from the authors have to permit. If they use it with a permission, it's illegal. That's the first. You have to make sure, and then we have the mechanism like music for the collective management, and maybe for the platform it depends if it's related music also for using CMO. Or maybe for journalistic, maybe we are still in discussion. Is it we can use both system? Is it direct licensing or maybe our collective management system? It depends on the agreement. If the B2B, it should be direct. I mean from the platform and the news publishers like that. And we're still discussion with our DPR side. So which system that we can use? But for the music, we already use for the collective management system, ECL, extended collective license. So we collect all the music and then we give and we distribute depend. But in our revision, we have to make sure it's based on the data. We have to make sure if the metadata is correct or not. Like music as who's the writer of the song, who is the arranger, who playing the guitar, who playing the piano or something. We have to make sure it's correct. That's why, besides we make sure the mechanism, we have to set our data in it. In music, we built system we call PDLM, National Music Central Data. So like we have to make sure the song, they put the data as well as we mandate in our regulation. And so the ISRC, and the code is, we have the code also. And also we have to, and then we make sure for the books also, and from other work, kind of work. So, that's why the main point we revise our regulation is we have dealing with the AI, and not also for the AI, and also for the for the other work that not really fully covered in our existing law. So we have to still learning the mechanism. So like journalistic, we want to discuss with German, with Denmark, how we're dealing with the CMOs in journalistic, and also we are going to discuss with IFRO how to dealing with the CMOs in books and literation, and also we are. Couple of months ago, I attended the international conference of artists research right in Philippines. So we are going to learn how to dealing with the CMOs in research rights. So I think we are still in that position.
Okay, understood. Jens, if I were to ask the same question from you, Desmond, you might have an opinion on that. How does it work in Hong Kong? Or any other territory that you are working for? How's the infrastructure being developed, or how is it evolving to address this?
Okay, now first, do you know why there's no question from the floor? Because they're using AI to answer the questions. Yeah, that's the experience that I got from the university, because I also teach part-time at the universities. And when I deliver the lecture, the students always note their heads. They tape record my lecture, and then they use AIs to generate notes for themselves. And they ask questions. Instead of asking me, they ask the AI to answer the questions. So that's the day-to-day routine that has become the day-to-day routine. Okay, coming back to your questions. Now, in terms of the compensation for the creators, in Hong Kong, it is true that AI is still something very advanced, and the law is always lagging behind the technology. So we don't have, at the moment, we don't have a very sophisticated legal framework to deal with the compensation issues for AI-generated works or AI-assisted works. And my quick answer to you, like what I deliver at my presentation, is that we always try to argue that, well, AI is just a tool. It is like a pen in my hand or a computer on my desk. Okay, I'm just using it as a tool to create the work. I'm still the mastermind of the creation. So the traditional applies to my work, despite I have used AI to assist me in creating the works. In this way, I, under the traditional law, may still be able to claim the adequate compensation for my creation. So because there's gray area, and there's room of arguments, so we always tried to protect our position by sticking to what has been existing in the current law. All right? And that's why the important message to you today is that, well, don't tell anybody that, well, this is my AI-generated work. Don't say that. It is my AI-assisted work. Okay? I am still the mastermind of this piece of work. Okay. So that's the quick answer.
Right.
If this is not enough, then please type in the question to Microsoft Copilot and get a more detailed answer.
Right. If you were to advise a broadcaster about what they are planned for the next 3 years or 5 years, what would you ask them to prioritize with regards to this matter?
Okay. I think we should do it now rather than later. As my company is also very advanced in using the AI technology, we have been using different models of AI technologies in the process of our creation. For example, the demo that we showed to you, it was one of the very first kind of AI productions that we broadcast in Hong Kong and in our overseas jurisdictions. So my advice to you is, like I said, document your creation process, okay? Just like my fellow speaker mentioned to you in her slides, that you need to keep the initial prompt and the final output. And not only that, also the revision that you have made in the midway of the creation process, because this is a very good piece of evidence to show that, well, we human beings are still controlling the whole creation process. We talk to the AI. We don't let the AI dictate us, okay? Instead, we dictate the AI. We talk to the AI, and we give direction to the AI. We give instruction to the AI how to create the work or how to revise the work and how to improve the work, okay? So keep the records. It is very important. And even more important is, before you use the AI tool, always read the T&C of the AI tools, because we have experienced that some AI tools, in the small prints, they will say that they will share the copyright with us, or some of them even say that they will get the copyright of the output of the work that's created by the AI tool. And for these AI tools, do not use them, all right? Because you don't want to get yourself involved in any legal dispute, whether the final output is wholly owned by you in terms of the copyright ownership. Okay, so there are quite a lot of AI tools which do not take away or share your copyright ownership. And don't read the T&C only once, because the T&C could be revised by the platform. So you may need your legal staff to regularly revisit these T&Cs to make sure that your copyright ownership could not be challenged in the subsequent years.
Thank you. Haru, you work for a public broadcaster. Could you share your opinion on whether public broadcasters, given their mandate on people's interests, putting that forward first, whether the stance on AI for public broadcasters and private broadcasters or commercial broadcasters be different?
Well, according to the types of broadcasters, I think it's up to individual countries, I imagine. But when I think about the Japanese system, I would say basically there are no differences about use of AI. Well, for example, I work for NHK, which is public broadcaster. So how can I say? Well, people watching our activities much more strictly than commercial broadcasters, I must say. So we are sort of discreet about any kind of activities. But on the other hand, AI technology is progressing, of course, and there are good aspects as well. For example, it can make the work, go more smoothly, and the work efficiency will improve as well. So it depends on how we use it anyway. But as we are broadcasters, we also need to think about, how our activities will give an impact to the people, particularly, for example, copyright owners, including performers, for example. You might know that many copyright owners are beginning to address the concerns about, the use of their copyrighted works for AI issues, and Japan is not an exception either. So we always need to keep a balance, between how we can properly use the AI and how we can also care about, the respect for other, copyright holders, copyright owners' rights as well. I think that comes to my mind about your answer, about your question.
Okay, do we have questions from the audience? Yeah. Would it be possible to hand over a mic to them?
Hi, this is Esra from Turkish Radio Television Organization Corporation in Turkey. Thanks for all for your detailed information about your legislation. These are really beneficial for us. And I would like to ask, to be honest, Hong Kong aspect, because this is really, how can I say, different for me and for my country. It sounds different in general legal perspective because of, you know that in general we are seeking human creation. But you mentioned, you said that, for example, AI generated work, sometimes you don't need to find human creation for this. It is really, how can I say, different for in general aspects of the legal perspectives on AI. So I would like to ask the main reason, maybe, because why your country, how can I say, to this perspective to AI. I guess I found this really encouraged to technological developments. So I would like to ask you. Thank you so much.
Okay, if I understand the question correctly, you are asking, well, if it is AI generated work and there's no human authorship, then how can you claim there's copyright protection? Sorry, I can't hear you.
I will look.
She's asking about
The main reason under this perspective.
Content can be copyrightable, and maybe she wants to know about the reason or.
Oh, okay, I see. Sorry about that. Thanks for the explanation. Okay, so how come Hong Kong has a computer-generated provisions to protect AI-generated work? And the answer is very simple. The Hong Kong government was very lazy. It simply copied the UK legislation, which is the CPDA, the Copyright Protection and the Copyright Patent and Design Act, 1988. Hong Kong has this piece of copyright ordinance and added in 1997, almost 9 years after the UK promulgated its legislation, and there was a copyright-generated provision in the UK legislation, and the Hong Kong government simply copied almost 99% of the entire provisions of this into the Hong Kong law. And would you say that, well, they were very smart in contemplating that 30 or 40 years later, there will be AI generation in the world? Of course not. So it was purely accidental that they made that kind of provision in the law. And the law could be interpreted in such a flexible way that it covers the AI technology nowadays. Yeah. I hope I have answered the question. Yeah.
Thank you so
yeah,
much.
I would like to add on this one because I happened to, hello? Yeah, because I happened to do the research on this, I can add a little bit on this part. Can you hear me?
Yes, we can.
Okay. So yeah, it's actually currently there is a big, I think we don't have a disagreement on like AI itself cannot be author. So the key issue is when the human can be considered as author. And then I closely examined like two cases. One is I also mentioned in my slides. One in US, the Jason Allen case, which give more than 600 prompts, and the Levi Liu case, which is get copyright protection for that AI generated image. If I don't remember wrong, it's more than 100 times prompt. However, the judge in China think that we do not need to considering about which part is AI generated, which part is human. We considering the whole process, and the human make the personalized judgment, and the human's expression eventually demonstrated by the whole image. And also the judge particularly said that we wanted to promote human to use AI to create. That's one of the key reasons we give the protection of. It's not say that purely AI generated. It's a human use AI as a tool to generate. However, the US will say that, hey, I do not want you to register the AI generated part. You need to tell me which part is human, which part is AI. Which is for Jason Allen case, you find out Jason Allen refused, which is very hard in some way to say this image, human and AI together to eventually make this image. Which part is human? Which part is AI? It's very hard. So, so right now there is a sort of a different judicial practice. And also in the academic, there is also a debate. Some people strongly support, yeah, let's AI be author even. So myself, I'm also currently, as I said, I'm writing a paper on it. And I think some judges say that we want to promote using AI, then it's promote human creativity. But some people will say, if you give a corporate protection to like a Li Liu case, that image, they will damage human creativity. So it's really, what side are you on? So depend on, yeah.
Thank you, Sarah.
Okay.
If you very quickly move
I
on
have a
to the-
question. Thank you. My name is Harisman. I work for public broadcasting in Indonesia. I work for TVRI for 26 years now. And as you know, TVRI was established in 1962. And my question is, maybe it's also the question for other public broadcasters, how can we protect our content? We have archives and also original content since 1962. How do we protect our content and our archives from being used by AI models without authorization or maybe fair compensation? That's my question. Thank
For
you.
training purposes,
Yes.
imagine. Yes.
How can we protect our archives without being used by AI models?
Right. Would any of the speakers like to comment on that?
Okay, the first thing they have to, from that, the corporate is legally protected by in the creative system. So since it's published, it's already protected by the law. And then we have, and the second is, you have to make a second step. You have to make a recordation of your content. So we have legal data in Indonesia. So that's why in our revision we have to we make to build like in journalistic system mechanism of the royalties in journalistic that related to platform AI. So we have to make sure that the data is the data that they take to as a training data is they can in transparency, and also they have to make sure it is content is legal or not. So, but how we can how Indonesia can protect the content if we don't have data? So we ask, the journalists or the publisher, we have to make a recordation in Indonesian system. So we have data. But if it's too, if there's mass data, if there are a lot of contents, so we have to make sure that you have, the documentation, the archive documentation is belong to you. The first time you publish, it's already protected by law, but when the platform AI, the AI like JetPit, Gemini, or maybe Cloud take your, that's a point that in our revision we have to make sure it's protected and make sure the mechanism of royalties is fully controlled by the government. Like music, they are struggling with that also. We have a lot of music, and then they're using an AI, Suno, something like that. They have to, in our revisions, is they have to, we have to have a permission from the content creators, from the authors, or from the like your company as a right holder. But we still in discussion in the what the mechanism, what the exact mechanism that we can use. But the main point is, if you feel that your content is being abused or being used, and you can prove by the law, so you can use the mechanism of the criminal mechanism, or we have a mechanism of the notice and takedown in our ministry, so we can you can give us like what kind of platform, what kind of like that people or content that being abused by other people, and then we can block them in the system, or we just in Ministry of Law is just give the recommendation, but the execution is in Ministry of Digital, ComDigi. So you can contact them also, because they have a unit that concern in AI. Jadi ada we call it in Directorate of AI. So you can talk to them if in AI side. So but in our regulation, if you have a proof that your content is being abused or used by the AI for training data, and you have proof, so you can come to us, and we can make sure that we can give the Minister of Community recommendation to block the site. But the important is that we just can block the content is in Indonesian area. So we make sure that it's in this forum that can we make a MOU or maybe some kind of agreement that once it's blocked in Indonesia, it's also blocked in Asian. So they can open the site or in Indonesia. So the problem is, the weakness is in our regulation is just blocked for Indonesian site, Indonesian regulation. But if you use VPN, if you use just one step ahead, you go to Malaysia, you can open the sites. So it's the problem. So in this forum, I want to ask you, can we have an MOU or something? So if we block the system, block the site in Indonesia, it's also give a notice from the other country to block also the system or the content, or maybe the platform or some or the sites. So make sure that it's blocked from in regional way. So I think it's the next step. So I think that's for me.
Sorry, I will be very brief. I probably, in addition to that, we probably need to take into account the nature as a broadcasters as well, because broadcasters are both not only a copyright holder, but we also a user of the copyrighted works as well. So we need to keep the balance, between the two natures, and because we are expected to provide, information and serve the public. So in order to, but an archive is probably one of the, carried out for the purposes as well. So we need to keep the balance when you think about, whether you would like to, how can I say, protect your archived, works, and you need to have a kind of an internal, discussion thoroughly from various kinds of aspects, including the nature of the broadcasters.
I also would like to quickly add about the current situation on this question. Yeah, I also want to quickly add on this. This is one of the key questions actually on the input side, training large language model. And actually, currently, the most, if you track the AI, Gen AI and the copyright case in the court, actually, this is one of the most dispute area. And currently, to my knowledge, the US got the most, the cases a lot, increasing. And start from, we need to also considering like some like comedian, even like sue the big tech company, and like New York Times, some big company together to sue to protect their copyrighted works. And I would like to say that currently they're still pending in the court in the US. It's pending in the court. The judge need to decide whether it belongs to fair use whether this belongs to copyright exception, you know. And also, eventually, I think a lawmaker have to be more clear about this. Training large language model use copyrighted works. How is this fair use? Is this need to compensate the copyright users, copyright holders? Actually, I saw a lot of debate and attention, and I also see that different country jurisdiction, maybe they have different concerns. Some country may say, hey, we want in some way to make sure the tech company have enough data to train the models. And some maybe say worry about human creativity, and then maybe more turned on protect the copyrighted works. And personally, I think that for the company, if they want to protect their copyrighted works, they can use several ways, such as in order to wait the law is more clear, limit the access. So all your archive, if you really don't want people use it, maybe you can control the access. And also they're talking about opt-out. Eventually, I think in the future we'll be more clear on this. And also maybe make a deal and bargain about if you want to use this to training the model and what is the remuneration. Unfortunately, some of the foundation model already trained. And also in practice, how to prove there is infringement is another difficult issue actually, if you see the case. Okay, that's what I can comment on. Yeah.
Thank you, Sarah. I think it is about time that we wrap up our first session. Thank you to all our speakers. And if you do have more questions, you can actually bug them during the coffee break, I'm sure. And you could always email Sarah regarding questions that you want to ask her. I will hand over the proceedings to Dr. Simantan.
Let's just give a round of applause to our speakers. It was a very, very insightful session. Thank you so much. We will now all break for coffee, and if we can reconvene at 11:40, so just 10 minutes. Within 10 minutes, we need to be back because or else our later sessions will not fall in place. Thank you so much.
Thank you.
Thank you. Thank you so much, Ms. Hujian. Thank you. Mr. Marcel Sihan, Mr. Indra Singh, Ms. Yuyan, and Mr. Azwan Aziz and Ms. Galina to please come on the stage. Speakers for the second session, if you could please come to the stage. Thank you so much.
All right. Okay. Good afternoon, everybody. Welcome to the second session of the ABU IPLC conference. So my name is Karis. I'm from Sarawak Media Group, and I'll be the moderator for the session right now. So the first speaker is Mr. Marcel Sihan, chairman of the National Collective Management Organization for Related Rights Owners. So Mr. Marcel, please proceed.
Thank you. Let me take the microphone first. Okay, good afternoon, distinguished chair, colleagues and friends. First of all, allow me to thank ABU, Intellectual Property and Legal Committee, and RRI as host for inviting LMKN into this very timely conversation on AI, copyright, royalties in the digital content economy. Again, it is a privilege for us to share Indonesia's perspective on a topic that is at once very technical and also very deeply human. We need to ensure that in an era of streaming, simultaneous cast, webcast, OTT, and now AI, the value created by music still reaches the people who create it. So my assigned sub-theme is to ensure fair remuneration, the role of LMKN and music royalty schemes in the digital and AI era. So I will approach this from three different angles. First is how artificial intelligence and platforms are changing the royalty landscape. And second, how LMKN, Lembaga Manajemen Kolektif Nasional, is rebuilding royalty governance so that it is fair, transparent, and adaptive. And the third, how these efforts are being anchored in Indonesia's copyright reform and in regional cooperation. Okay. Next. Okay, let me begin with the changing landscape. So around the world, digital transformation has changed how music is produced, distributed, used, consumed, and increasingly even created. So music is now routed through streaming platforms, video sharing sites, social media, live streaming, digital radio, and digital karaoke. And at the same time, artificial intelligence systems are trained on vast data sets that may include music, and they are increasingly used to generate, process, and recommend content. The result is a tension that many of us in this room also recognize. On the one hand, the overall economic value of music is growing. And on the other hand, the distribution of that value is not always enjoyed proportionally by creators, performers, and right holders. In this environment, the traditional enforcement model of copyright, which is like waiting for an unauthorized copy and then suing for infringement, becomes increasingly insufficient. So the practical question is no longer only who is the owner or is there an infringement. It becomes, can we see what is being used? Can we license it? Can we enforce obligation? And can we distribute the money back to creators and right holders in a way that they understand and trust? Okay. In practical terms, the artificial intelligence challenge is no longer abstract. It includes training data sets that may contain music, AI-generated songs, voice cloning that imitates performers, and style imitation that reproduce the recognizable creative identity of composers. Each of these raises not only question of authorship of infringement, but also questions of licensing, attribution, and remuneration. So when we discuss AI and music, we should be careful not to treat it only as a technological issue, but also a governance issue, the market issue, and remuneration issue. Against that backdrop, I would argue that legal certainty in the digital and AI era rests on 4 pillars. The first one is clarity of rights. Who owns what and in which layer of the work? Second, transparency of use. Who uses what, where, and under which terms? Third, fairness of remuneration. Who pays how much and how that value is shared? And fourth, enforceability of obligations. What happens when someone chooses not to comply? Without all 4 pillars, protection remains declaratory on paper. This is important. Remains declaratory on paper, but weak in practice. This is why so many issues now converge on the common practical questions. Who bears responsibility and who gets paid in a digital content economy shaped by AI and platforms? Let me now briefly situate Indonesia. Under the law of 28 of 2014, Indonesia has a comprehensive copyright framework. Protection arises automatically once a work is expressed in tangible form. The law recognizes both moral rights and economic rights and acknowledges multiple layers of rights in music, including the right of authors and composers, performers, producers of sound recordings, and broadcasters. This gives us a solid normative foundation. However, that foundation was designed for a world before large scale of AI training and before the current dominance of streaming, simulcast, webcast, OTT, and other digital platforms. This is where LMKN comes in. So LMKN must be understood not only as a collector and distributor of royalties, but also as a collective licensing institution, a provider of usage data, and a bridge between music users and right holders. And even as technology changes, the principle the use of work still requires a legal basis. Economic rights remain attached, and creators remain entitled to economic benefit from the exploitation of their works. In this invitation we received, LMKN was asked to speak about ensuring fair remuneration. So for us, that phrase carries 3 attached adjectives. It must be fair, it must be transparent, and it must be adaptive. Fairness concerns how value is allocated among authors, performers, producers, and other right holders. It requires clear rules, consistent application, and alignment with the real economic pathways through which music generates values. Transparency means that creators should be able to see the usage data. They should understand the distribution rules and trust the management of the money collected. Adaptive means that the royalty system cannot remain trapped in the analog era while value moves into digital and AI-shaped environments. This adaptive dimension is particularly important because music now generates value across a much wider field than traditional broadcasting alone. So when we speak of digital uses, we should think not only of streaming in the narrow sense, but also of video sharing platforms, social media, live streaming, digital performance, digital radio, and digital karaoke. These are all environments where music creates economic value and where royalty logic must increasingly follow actual usage. For Indonesia, this means that LMKN's licensing horizon must explicitly include streaming, simultaneous cast or simulcast, webcast, OTT services, online radio, social platforms, and other hybrid digital uses. If these new channels generate value but remain outside the effective royalty system, fairness will collapse. At the international level, several issues are already being discussed more explicitly. So these include dataset licensing, AI transparency, disclosure obligation for training datasets, collective licensing, and even extended collective licensing. Indonesia does not need to copy any model mechanically, but it does need to prepare an adaptive governance framework that can engage with these developments. This is important because AI models, platforms, and content markets are all cross-border by nature. National system must remain rooted in domestic law, but they cannot be designed in isolation. This brings me to the ongoing revision of Indonesia's copyright law. Public information about the draft indicates that it will address AI and royalties more explicitly. In broad terms, three elements are particularly important. The first is AI-related provisions. The draft direction reportedly acknowledges AI-assisted and AI-generated works and begins to frame training uses and outputs. The second is platform duties. Digital platforms are expected to pay royalties, share usage data, cooperate with collective management bodies such as LMKN, and support near real-time reporting. The third is enforcement certainty. The law seeks to clarify who qualifies as a user and who is the obligated payer across different business models. Again, for LMKN, this definitional clarity is essential. We cannot enforce what we cannot define. But diagnosis alone is not enough. We also need a roadmap. From our perspective, that roadmap has 4 dimensions. First, regulations, technology, institutions, and governance. Regulations includes AI legal certainty, licensing design, and public education. Technology includes dataset transparency, national metadata, digital fingerprinting, and an interoperability of data system. Institutions include strengthening LMKN and collaboration among collective management bodies. Governance includes structured cooperation with digital platforms and the development of AI-ready royalty administration. This effort must also be sequenced. So in short term, regulatory refinement, and public education are necessary. In the medium term, we need integrated national data and metadata standardization. In longer term, the goal should be an AI-ready royalty system and a fully functioning digital licensing ecosystem. Let me close by returning to the regional perspective of ABU and IPLC. So Indonesia's experience can contribute at least 3 things to this dialogue. First, a concrete example of a national collective being re-engineered for a data-driven digital environment. First. Second, a live case study of how AI issues, platform obligations, and copyright reform can be integrated. The third, a commitment to regional cooperation, recognizing that no country can solve these issues alone. When we speak of ensuring fair remuneration in the digital and AI era, we are not only talking about money. We're also talking about trust, visibility, accountability, and workable compliance. Technology will continue to evolve, but respect for human creativity must remain the foundation of a sustainable music ecosystem. So for Indonesia, for us, the path forward is to move from declaratory protection to operational protection, so that rights are not only recognized in law, but can actually be licensed, monitored, paid, verified, and enforced. Thank you very much.
Thank you, Mr. Marcel. Our next speaker is Mr. Indra Singh, the Director of ABU News. Next, you're the third one.
Thank you very much. Well, I feel a little bit of an alien in the room because I don't come from a legal background, but we deal with legalities on a daily basis. And you know, when we talk news, there's no way that news can go forward without having the legal framework in place. So before I get going and talk a little bit about Asia Vision and what we do and how we counter this, it'd be good to play that video that I have got. It's not a very long video, it's about 4 minutes long, if they can bring that up. Thank you.
Of truth or realism.
There may be no returning the AI genie to the bottle.
If we start to push out AI-generated content that changes the narrative of a story, we are no better than any bad actors out there. Greetings, I'm Alex Golden. I'm the Senior Director for the product team at NBC News Group, and welcome to NBCU Academy. In terms of defining artificial intelligence, when used properly, it is the automation of human intelligence. It should make life easier for things that currently take a lot of manual activity to do. We've been involved with artificial intelligence and machine learning for a good number of years. We started off with something as simple as transcriptions. People in there transcribing in a room off of video. We thought that we could also cut costs by getting an AI solution that was more self-serve. They put it into a system as an MP3, get it back, it's fully transcribed. The other side of that's capturing the data of pictures, the picture to text, Biden at the podium, Trump with a red hat. Those are things that currently would be manually logged. The thing that always comes up is whether AI is a quote-unquote replacement technology. We don't see it that way. We see it as an assistance technology. Our charter for using AI as a company is to have it help and improve workflows, and where it fits the use case, replace workflows, but not replace people. It should always have that human element of being monitored, being attached to some amount of human interaction or workflow, so that we make sure it's being used the right way. The big elephant in the room becomes generative AI, and obviously that's the huge buzz on the block.
So how can I help?
Generative AI is AI that can create text, images, and media from human commands. Go ask it to do something and it'll do it. You can talk to it.
From fake pictures of Donald Trump getting arrested to a fake video of President Biden instituting a military draft.
If we use something on air that was faked, that's a huge potential risk, of course. But the other risk is if somebody takes our content out there in the public space and changes it, what if somebody were to take Jim Cramer's words, buy, change them around, sell, that could affect markets. There's actual real-world ramifications.
Moving forward, we need to be more vigilant with what we trust from the internet.
A lot of our editorial teams are using very time-consuming activities to be able to check for fake content. What AI can do is quicken the process. We want to use fire to fight fire. Employ AI as the best way to suss out the AI being used by bad actors. There probably is more upside on how journalists can actually use it, whether it's to take large quantities of text and summarize, to generate conclusions based on meetings, upscale images. These are all things that I think journalists are starting to tackle now as a way to have this AI improve the work that they do. Don't use AI in a vacuum. Make sure that you have brought up this attempt to use AI to your own team leadership. Don't let AI do the work for you in such a way that you then become the self-perpetuating replacement of your own job.
This is serious, breaking news, but a little behind the scenes, a little flavor. I'm with one of the most legitimate correspondents on Earth.
Have fun and experiment with what is out there. It can be fun to play with, for sure.
AI is not only being used to clone actors' faces and voices, it's also being deployed to do CGI and visual effects faster and easier than ever before.
Should journalists be afraid of AI? No. But should they be cautious about it? Absolutely. We still believe that journalism is done by journalists, but if we're going to use AI, we still need to maintain the editorial best standards and best practices. Those don't go away. AI cannot be used as a shortcut. It's the exciting new stuff that we're working on that excites me the most. I'm Alex Golden with NBCU Academy. Thanks for watching.
So that's just a little clip from one of the traditional broadcasters out of the US. So at Asia Vision, as most of you know, we deal with hundreds and hundreds of news content, particularly from our broadcast partners on a daily basis, and with our sister unions as well, which ranges from Europe to Africa, Caribbean, to Latin America, and the Arab states. Does AVN have a role or responsibility of what is loaded by our members? Is the question we keep on mulling about and talking about, and many of times. I know Sima and previously others have worked on it. If the content is being loaded by our members and then being used by another member, who holds the responsibility? Who is at risk? Should it be deepfake or should it be content that is not true? It's a fine line because AVN is the facilitator through ABU. However, it is our responsibility to ensure that whatever is pumped out through the platform is checked and thoroughly checked, and that is where we try to work with tools to be able to identify. Mind you, I'm not saying that our members do pump out fake news or fake stories, but there are times, and things that come into play is using images, perhaps AI-generated images in news content, but not declaring it. A good example is the recent, in February, when we had the Iran war breakout. There was so much content that was being put into the system, not only from our members, but from our partners as well. Many of those content that came in, particularly from one or two of our members, was being questioned a lot by fellow members because it had content that was not readily available elsewhere, and it sort of was being looked upon as propaganda material or something that was created using AI tools or created using different tools that were available. Now, how did we manage to counter that? That is where AVN's role was very important. Anything that did not fit the bill of what we try and promote was totally taken out of the system. We could have gone through this whole process of probably trying to identify each and every single frame of the footage, but as mentioned by NBC, the video we watched, that means more human time to sit down there and look at hundreds of hours of footage. And at Asia Vision, we don't have that type of manpower. I'm just giving an example of what happened at the Iran war. Then, a couple of our members would load something on the platform without restrictions or without source. And if someone like the EBU picked up upon it, their first question would be, where was this sourced from? And if it is genuine. So that meant that we had to, before it got published, look through all of those. To be a trusted news exchange, I think it's very important, and I come from a perspective where I've worked with Rosa at my previous workplace, and before that, we never had a legal team in place at the Fijian Broadcasting Corporation. And we had a number of cases whereby, even though AI was not, at that stage already, but there were other issues around picture usage, around image use, around reproduction of images used from elsewhere. I feel if newsrooms do not have legal expertise in this day and age more than ever, we are in for a rough ride. I think it was in the first session, if I'm not mistaken, the talks about cases ending up in the US courts, number of cases ending up in courts around the world. Newsrooms very soon will have to start answering because the third-party users do not care about things. And that is where our responsibility as news directors, as heads of news organizations, is very, very important. With that also comes how much of a legal training are we giving the news people in each individual newsroom or organizations or unions. That is where, and I come from an experience of having worked in a newsroom, having led a newsroom, whereby many times legal is seen as something like, totally not part of our team. Because legal might tell us, don't do this story, because there's a loophole there which could come back and, land us in trouble. But the mindset needs to change, and later this year at the Global News Forum, and earlier this year at the coordinators meeting, we were fortunate to have Dr. Sima. Later this year to be hosted by the ABC in Sydney. We have a session there of news and legal aspects of how we do things. Because for me, it is very important that each and every member or each and every newsroom, at least within our Asia Pacific Broadcasting Union, understands that just like Asia Vision, just like the individuals, we need to be working together as a team. Now, the other thing is, it's your reputation. So trust and truth is very important, because if we, as Asia Vision or Eurovision or ASBU, etc., the sister unions, if we are not able to provide the trust and truth to our members by getting involved in this AI era, we are losing the trust not only of our members, but of people. As it is, people are switching off traditional media. They are going across to digital and all other sorts of media. So it remains our responsibility of ensuring that we have that. From content responsibility point of view, it is very important to have a set of rules in place for each of the newsrooms, and I know most of the newsrooms do, most of the broadcasters do, but you'll be surprised that some of our members don't have an AI policy in place for newsrooms. And they're very honest. They have spoken about finding it tough to legally have a legal, or not really legal, but to have the rules in place, or trying to find a word here, to ensure that the journalists and the newsroom is able to use that platform to refer to, should they be in any dilemma, to be using content. I think that's where we can work together. We've got expertise here, and our members range from very big organizations to some very smaller ones around the Asia Pacific and beyond. I think if we can work together to help each other, we will be fighting this. It's just a small step. I totally agree with, I think it was earlier on, trying to get an MOU or trying to just work with each other. That is going to be very much. So just finally, before I wrap up, I think one thing I'd like to say is newsrooms and news people need to change their mindset, involve legal, work with legal to ensure that when that call comes one day or a writ is served one day, you are in a safe place because you've done your 101% check rather than just going because you wanted to break news and ended up not having the original content, etc. Thank you very much.
Thank you, Mr. Indra. Our next speaker is Ms. Yu Yan, the corporate officer from China Media Group.
Good morning, everyone. I am Yu Yan from China Media Group. In China, generative AI is rising quickly. Almost everybody uses AI to assist the life and work and study. Just as Desmond mentioned, students, they don't ask teachers questions, they just ask AI, and AI gives them answers. But nowadays, especially recently because of the deep fakes and ethical risks brought by AI in China, actually people are more cautious now. For example, when people use AI in program production or other work, we are now use it in a more careful and more cautious way. People are coming down compared to the previous excitement, pure excitement. So here I have a little story. There's a place. There are many big mountains, and there grow many kinds of mushrooms. And local people love mushrooms very much. But the question is that some mushrooms are poisonous. Some mushrooms are not poisonous. And a group of people, they went to go hiking in the mountains, and they asked AI. They found a bundle of mushrooms, and they asked AI, are these mushrooms poisonous or not poisonous? And the AI answered, not poisonous. And they collected the mushrooms, go back, cooked them, and then turned out poisonous. They were all sent to hospital. So this is a true story, and that's why people are now getting more cautious now. Today, actually, I'm going to provide a case study of a sports copyright issue. I was planning to talk about the World Cup, actually, because the World Cup has just concluded, and it was a very hot topic, and China Media Group has made a very successful copyright negotiation with FIFA. One of the best negotiations with FIFA in the past history. But we are still doing the summary work yet. I don't get the data yet. So I still choose to talk about last year's the World Games 2025 Chengdu. Actually, our copyright work are more or less the same. So the slides consist of 3 parts. Part 1, brief to the sports event. Part 2, our copyright protection for the games and achievements. Part 3, joint efforts by various sectors of Chinese society to build a favorable environment for copyright protection of sports events programs. Now, part 1, brief introduction. From August 7th to August 17th, the 12th World Games was held in Chengdu, Sichuan province of China. This is the first time that the Games has been hosted in Chinese mainland, so it has great significance for the Chinese people. And at the highest level international comprehensive sports for non-Olympic sports, the World Games and the Olympic Games actually, they complement and reinforce each other. nearly 4,000 athletes from more than 100 countries and regions around the world gathered in Chengdu. This is the largest one with the most athletes participating in its history. Among the athletes, the oldest is a 68-year-old archer, and youngest is an only 13-year-old squash player. They competed in 34 sports disciplines and over 250 events with a total of 256 gold medals awarded. Next slide. Yes, here I have a video to show you. Please pay.
闭幕式从一个短片开始，鲜活的影像串联起本届世运会的点滴，浓缩了这场盛会的难忘记忆。
欢迎来到成都。8月7号，成都世运会开启了属于我们所有人的10个日夜。
Thank you for watching. That's our CCTV5 sports channel, broadcasting of the games. Now let's come to the copyright business. First is acquisition of rights. Some Chinese experts have been doing research in this field, and they hold that there is a sports event media copyright industry chain with the upstream owners and operators of sports events, including IOC, FIFA, NBA, and so on. The midstream sports media, that means broadcasters, internet, social media, and the downstream consumers, derivative product producers. And before broadcasting a sports event, we usually sign a contract with the event organizer or its agent to get the rights we need, including rights for broadcasting, sub-licensing, and derivative goods. In accordance with our contract with the Executive Committee of the World Games, we acquire the exclusive all media rights and exclusive sub-licensing rights for the games in Chinese mainland, Hong Kong, Macau, and it's entitled to take anti-piracy actions against any infringement. Now please have a quick look at introduction to China Media Group. Yes, next, please just quickly go through it. Thank you. Given the big international significance, social value, and economic value of the games, we attach great importance to the copyright work of this event. Before the opening ceremony, next slide. Next slide. Next. Yeah, here, thank you. Before the opening ceremony of the games, we issued multiple copyright statements to clearly declare the copyright we own, warn of infringement risks, and delivered early warning letters to potentially infringing platforms for public notice. These have laid a solid foundation for our later work, and during the games, we deployed dedicated working staff to closely follow the event schedule and implemented 7 multiple 24 real-time monitoring to promptly detect various infringement acts. In terms of on-demand service, short video infringement was the most prominent. Most of such infringing content was uploaded by users featuring no costs, fast dissemination speed, and the ability to gain traffic in a short period. Meanwhile, there existed quite concealed and diverse infringement methods. So non-authorized platforms provided live streaming and on-demand services of the program through deep links. In response to this, our team worked on duty 24 hours every day, taking strong measures throughout the whole process, with attention paid to all aspects. We conducted comprehensive monitoring and real-time handling of infringing content across the entire network, collected full evidence against the platforms, especially those social media platforms with severe infringing acts, and we delivered lawyers' letters immediately to defend our rights. And after the closing ceremony of the games, we pursued legal responsibilities of infringing entities in accordance with the law. For entities that committed serious infringements with severe impacts, we filed administrative complaints or initiated legal proceedings to pursue their legal responsibilities to the fullest of the law. Joint efforts have been made and practice achievements are seen in China. Yes, please, quickly, next one. And next. Yeah, here, thank you. Professor Wang Yong from the Law School of Renmin University of China, he made an in-depth analysis of the practical difficulties in the copyright protection of sports events programs. He hoped that current sports events program shows three major copyright characteristics. The first one is high copyright acquisition costs. High copyright acquisition costs over the past decade. The costs incurred by Chinese domestic entities in purchasing copyrights for foreign sports events have grown obviously. That's a very high burden. And second is complex history of legal disputes. Before the third amendment to China's copyright law in 2020, there were repeated disputes over issues such as whether sports events programs are copyrightable and the legal definition of online live streaming. These were basically resolved after the amendment to the law. And number three is significant differences in copyright terminology. There are actually barriers to the conversion of legal terms between China and foreign countries because we have different language systems and different academic systems. So as well as between the legal community and business departments in China, which may easily lead to disputes. Professor Wang Yong called on the academic and industrial circles to strengthen cooperation, promote the unification of legal interpretation and industry practice to adapt to new challenges in digital age. As CMG had long been engaging in the copyright protection of major sports events such as the Olympic Games and the World Cup, we have invested a large amount of human resources and money and other resources in the broadcasting. So we have a deep understanding that copyright protection is directly related to sustainable development of the industry. The protection of sports events program in China has benefited from the joint support of all sectors of the society. However, in the face of diverse patterns of violation and the delay of platforms in fulfilling their responsibilities, it is still necessary for us to work together to stimulate the innovative vitality of the industry. Especially now we are in the new AI era. New challenges are facing us in the future. So there is still a long way to go. That's all for my sharing. Thank you for your attention.
Thank you, Ms. Yu Yan. Our next speaker is Mr. Aswan Aziz, the finance manager of ABU.
Test. Assalamualaikum. Good afternoon, everyone. Distinguished Chair, respected speakers, ladies and gentlemen. First of all, I would like to thank ABU Legal Department, Ms. Dr. Sima, and our colleagues at RRI for inviting me to participate in this conference. Just like Indra mentioned earlier, looking at this today's program, I have to admit something. I felt a little bit probably the odd one out because most of the speakers here are legal practitioners, I could say, IP specialists, maybe copyright experts. I am not. I come from finance. So at first I wondered what a finance manager could possibly contribute to a room full of legal experts. Then I realized something. Perhaps this is precisely why I was invited. Because once copyright is created, protected, and licensed, someone needs to ask a question. How do we turn those rights into sustainable value? Ladies and gentlemen, that is where I think finance comes in. Throughout this morning's session, we have heard about copyright protection, legal frameworks, emerging technologies such as AI, or as someone mentioned this morning, generative AI. All of these discussions are important, no doubt about it. Without copyright, there is nothing to protect. Without legal certainty, there is no confidence to license or commercialize content. But I would like to offer another perspective. A copyright, or a contract, or a license does not automatically create value. Value is only created when organizations are able to govern those rights effectively. Allow me to share a simple observation. Many organizations spend enormous effort negotiating agreements, sometimes months, weeks, massive efforts. Everyone celebrates once the agreement is signed. But after that, who monitors whether the license is being properly used? Who checks whether the royalty payments are received on time? Who measures whether the agreement actually delivered the commercial benefits that were originally expected? And who asks whether the investment made any financial sense? Those questions rarely receive the same level of attention as the contract itself. As someone from finance, I see governance as something much broader than compliance. Many people think governance means more rule. We saw with Marcel's presentation earlier on governance. Some might think governance means more approvals, more procedures, layers and layers and layers of compliance. But I see governance a little bit differently. To me, governance simply means ensuring the right people making the right decisions, using the right information at the right time. In fact, let me share you a recent experience. Only recently, I sat in a meeting discussing the acquisition of a broadcasting rights for a major sporting event. Around the table were colleagues from legal, operations, finance, of course, and the management. We were all looking at the same project, but each of us was asking different questions. Legal was considering the contractual obligations. Operations was focused on delivering the event successfully. Finance, of course, we were asking all those hard questions like what's the total investment? What are the risks involved? What are the ROIs? Blah, blah, blah. So that meeting reminded me that good governance isn't about one particular unit or department having the right answer. It's about bringing different perspectives together before a decision is being made. That is why I believe governance is ultimately about collaboration instead of compliance. To me, governance is like a steering wheel, not a speed bump. Having said that, this is why I believe IP should not be viewed merely as a legal asset. It is also a commercial asset. It is a strategic asset, and ultimately, it's a financial asset. In an era where traditional broadcasting revenues are under pressure, intellectual property may well become one of the most important assets organizations possess. Protecting IP is only the beginning. The greater challenge is ensuring that those rights continue to generate value for the organization and its stakeholders over many, many years. That requires collaboration because legal cannot do it alone, finance cannot do it alone, nor do operations, nor do technology. Success eventually comes when these functions work together, each contributing to its own expertise towards a common objective. There is one more lesson that I come to appreciate. Good governance is not only about making the right decision, it is also about ensuring that important decisions are made early enough so that each of these functions to contribute meaningfully. Because when difficult discussion only begin at the final stage of a project, organizations often find themselves making important decisions under unnecessary time pressure. Good governance, ladies and gentlemen, gives every function the opportunity to contribute before options become limited. That, in my view, is how we make better decisions. Before I conclude, allow me to leave you with 3 simple thoughts. Not as a finance professional, not as an accountant, but as someone who believes that good governance is everyone's responsibility. The first is this. Every IP, every intellectual property asset should have a clear owner. Not necessarily the legal owner, but someone within the organization who is accountable for ensuring that the asset continues to generate value. Too often, IP becomes everyone's responsibility, which eventually means it becomes nobody's responsibility. Someone must ask, are we still using these rights? Are we still protecting them? Are we still generating value from them? Because if nobody asks those questions, valuable IP property can quietly lose its commercial value over time. Second thought is this. Every major licensing or rights agreement should have a business case. Notice, I did not say a legal opinion, nor did I say a financial model, a business case. A good business case brings together different perspectives. Legal asks, can we do this? Operation asks, can we deliver this? Finance will ask, can we afford this? And ultimately, management will then ask the most important question, should we do this? Those are very different questions. But I believe, from my perspective, good governance happens when all of these 4 questions are answered before the decision is being made. My final thought concerns AI. We talked about it a lot this morning. And I have to be frankly honest, I am not an expert in AI. But AI is changing almost every aspect of our industry, not just broadcasting industry, but probably in our life. It generates contents, analyze contract, can identify copyright infringements. It can even assist organizations in monitoring the use of licensed content. These are obviously exciting developments. But AI does not remove the need for governance. In fact, I believe AI makes governance even more important. Technology obviously can provide answers, but it is only us can decide which questions are worth asking. Technology obviously can process information, but only us can balance commercial objectives, legal obligation, and organizational values. The future obviously will not belong to organizations that simply adopt AI, but it will belong to organizations that combine AI with good and robust governance. As an analogy, I look at AI as a big engine of a car, but governance is the steering wheel that decides where the car wants to go. Allow me to finish with one final reflection. Earlier today, we have heard many excellent presentations explaining how intellectual property should be protected. I fully agree, but perhaps we should ask another question. What happens next? Because once we have successfully protected our intellectual property, we have to ask ourselves, does it support innovation? Does it strengthen collaboration? Does it create sustainable value for our organization? Because if the answers to this question is a no, then perhaps that's where governance truly begins. Ladies and gentlemen, as finance professionals, lawyers, broadcasters, managers, we all see IP from different perspectives, different lenses. That diversity should not divide us. It should strengthen our decision-making. Good governance, again, is not about one unit, one department being right. It's about everyone contributing its expertise so that management can make better decisions. Perhaps that is the real value of conferences such as this, not simply exchanging legal knowledge, but learning how different professions can work together to protect, manage, and maximize the value of intellectual property. Thank you for your attention.
Thank you, Mr. Azwan. Our next speaker and final speaker, Ms. Galina Dobrescu, Head of Copyright and Related Rights at Radio Romania.
Okay. Now it's okay? It's okay. Okay, good afternoon, everybody. First of all, I would like to express my gratitude to the host for inviting me to the 32nd ABU Intellectual Property and Legal Committee meeting. It is a great privilege and an honor to be here and today and to share with you our company's experience regarding one of the most challenging aspects of the European Artificial Intelligence Act, the transparency use of deepfake technologies. For public service media, the most relevant provision is Article 50, Paragraph 4. This provision establishes transparency obligations for deployers of AI systems. In other words, it applies to organizations that use artificial intelligence to create or manipulate content, not only to the organizations that develop AI systems. Public service broadcasters clearly fall into this category whenever they use AI tools in their editorial activities. Before discussing our institutional experience, let us briefly clarify what the term deepfake actually means according to the European legislations. One of the strengths of the Artificial Intelligence Act is that it provides a legal definition of a deepfake. According to AI Act, deepfake means AI-generated or manipulated image, audio, or video content that resembles existing persons, objects, places, or other entities or events, and would falsely appear to a person to be authentic or truthful. This definition is particularly important because it contains three key elements. The content must be generated or manipulated by AI. The previous slide, please. The The content, the previous. Maybe I could try. Yeah, let me, okay. It doesn't work? I tried to, no. Okay. Yeah, this one. So this definition is particularly important because it contains 3 key elements. The content must be generated or manipulated by AI. There must be significant resemblance to reality. There must be a risk of misleading the public. Deepfake can include image, audio, video, or multimodal combinations. According to Article 50, disclosure must be clear, visible, easily accessible, provided at the time of exposure. European legislators provide one of the most important clarifications. If the deepfake is used in an artistic, creative, satirical, or fictional work, the obligation of disclosure remains, but in a proportional manner. The purpose is not to harm the creative value or the creative experience. For instance, a feature film that recreates a deceased actor, this must be disclosed, but in a proportional manner. Now, I would like to talk about a section that is extremely important for the press and public communication. AI-generated text on matters of public interest. Article 50, paragraph 4 also applies to AI-generated texts that are published to inform the public on topics of public interest, such as politics, public health, economy, security, elections, crisis, public policies. When does this obligation for text apply? Not every AI-generated text falls under this obligation. The following criteria must be met cumulatively. The text must be generated or substantially modified by AI. It must be published. The purpose of publication must be to inform the public. The topic must be of public interest. For instance, an article about election written by AI and published online falls under the obligation. An economic report generated by AI for the public falls under the obligation. An internally company email does not fall under the obligation. There is an important exception if the text is subject to editorial control and editorial responsibility. Artificial intelligence is capable of producing highly realistic voices. It can recreate public figures. It can generate synthetic interviews. It can create images that look entirely authentic. This is precisely why Article 50 introduces transparency obligation. The purpose is not to ban the innovation or to discourage public service broadcasters for using AI. Rather, it is to ensure that citizens know when artificial intelligence has played a significant role in creating or manipulating content. In this way, transparency serves as a safeguard for informed decision-making. This brings me to our own institutional experience. Although the legal obligation set by Article 50, paragraph 4, are only now becoming operational within the European regulatory framework, our organization decided not to wait until legal compliance becomes mandatory. Instead, we choose a proactive approach. Currently, artificial intelligence is already being used within our organization to generate illustrative images for certain editorial or communicational purposes. These images are not intended to replace journalism. They do not replace documentary photography. They do not replace editorial verification. Their role is purely illustrative. We believe that transparency should accompany their use before the deadline in the AI Act become applicable. For this reason, every AI-generated image published by our organization is clearly labeled as being generated using artificial intelligence. Thus, starting from mid-July, all images created with AI are labeled, and those created before mid-July of this year are scheduled to be labeled as well. As you can see, the 2 images marked with AI label were used by our employees to illustrate the article written and posted on our station's websites. Of course, under each photo, it states that they are for illustrative purposes, because we believe that transparency should not start with regulation. Transparency should start with institutional culture. One of the first practical steps taken by our organization was drafting an internal code on the responsible use of artificial intelligence. The purpose of this document is not simply legal compliance. Its purpose is to establish common organizational principles. It provides guidance on the responsible use of artificial intelligence, editorial transparency, human oversight, accountability, and safeguard public trust. Our goal is to ensure that artificial intelligence is used consistently across the entire organization rather than differing from one department to another. However, documents alone don't create an organizational culture. People do. Artificial intelligence is continuously evolving. Therefore, I forgot to tell that this code also contains an annex with models of the AI. This code also includes an annex with the AI labels applied by our employees where appropriate to inform the public when AI is being used. However, documents alone, as I told before, don't create an organizational culture. People do. And for this reason, our organization, artificial intelligence is continuously evolving. Therefore, journalists need continuous learning, editors need continuous learning, and managers need continuous learning. For this reason, our organization is preparing a structured training program dedicated to artificial intelligence. The goal is not to turn journalists into AI specialists. The goal is to help every employee understand 3 simple questions. Where can AI be used? When should transparency be applied? And who remains responsible for published content? These questions seem simple. In reality, they define the future culture of AI-assisted journalism. Ladies and gentlemen, let me conclude with a simple reflection. Throughout its history, public service broadcasting embraced many new technologies: radio, television, digital broadcasting, online platforms, social media. Artificial intelligence is simply the next chapter in this evolution. Therefore, the real challenge is not technological, it is institutional. How do we preserve public trust while embracing innovation? I believe that Article 50 provides an important answer, not because it introduces new administrative obligations, but because it reminds us of something journalists has always known. Transparency creates credibility. Credibility creates trust, and trust is the foundation of public service media. Artificial intelligence will continue to evolve. The technology will undoubtedly become more powerful. But one principle should remain unchanged. Editorial responsibility belongs to human. And public trust remains the most valuable asset that any public broadcaster possesses. For this reason, I would like to close with a sentence that, in my opinion, sums up the entire philosophy of artificial intelligence. Artificial intelligence can help us create content. Transparency helps citizens trust that content. Thank you very much.
Thank you, Ms. Galina. Such wonderful presentations from our speakers in this session. I'm sure they have a lot more to share with us, but unfortunately, we do not have time for Q&A. So if you have any questions, you may approach them during lunchtime. So thank you, everyone. We will now adjourn for lunch. Thank you.
We can give a round of applause to our speakers. That was a very, very insightful session. Thank you so much. We will now break for lunch, and we will reconvene at 1:35. 1:35, so we have around 35 minutes of lunch. All right, thank you so much. The lunch is being served outside.
If I had to live my life without you near me, the days would all be empty. The night
speakers to the stage. Okay, shall we? Okay. Good afternoon, everyone. I hope all of you had a good lunch. More importantly, how was that nasi padang just now we had? Was it nasi padang? Huh? Oh. How was the nasi padang anyway? Anyway, before we continue, I'd like to extend our sincere thanks to Andy and the RRI team for having us over lunch. Now let us move on to session 3. For those whom I haven't met, my name is Azwan. I am from the ABU Secretariat Office in Kuala Lumpur. So it is my pleasure to moderate this afternoon session. Let us first introduce the speakers. On the left of me is Ms. Jacqueline Ford from ABC. And then Mr. Alex Reza from RTM. And the third will be Ashwini Natison. So just a small reminder, we have about approximately 15 minutes per speaker. And I'll give you a heads up when you reach the 1 minute times. Without further ado, ladies and gentlemen, please join me in welcoming our first speaker for today's session, Ms. Jacqueline.
Hello? Works. I'll just pop this one down. There. Hello, everyone, and thank you very much for the invitation to speak today. I'm presenting from the perspective of a lawyer and governance professional working at the Australian Broadcasting Corporation. What I want to offer today is not a technology briefing or a legal briefing or a briefing from a journalist involved in content and editorial output. What I want to offer is a governance and accountability lens to the adoption of AI, which I think is critically important to maintaining trust in public media and the content that it produces. We're all operating in an environment where AI tools are probably already embedded in our organisations, in many cases without a considered governance framework that is fit for purpose. The question I want to look at is, what does fit for purpose actually look like for public media? How can we safely use AI to support trusted news, cultural content, public interest journalism, and universal access? I'll be drawing on Australian perspectives, which is what I know, and I'll let you know when I'm being specific about the ABC. Before we talk about governance, it's worth being precise about what we're governing and the risk if we don't get AI governance right. This slide does draw on ABC perspectives. It's the what and how for the ABC. It's a high-level overview of the regulation of the ABC that supports its key asset, which is trust. So on the left-hand side, we have the charter that requires that the services or functions that are delivered by the ABC have certain qualities. They must be of a high standard, they must inform, they must entertain, and the domestic broadcasting services must be innovative. The internal governing authority of the ABC is its board, and the board has various duties, including to maintain the independence and integrity of the ABC, to ensure that the gathering and presentation of news and information is accurate and impartial, and to ensure that the functions of the corporation are performed efficiently and with the maximum benefit to the people of Australia. So in terms of AI, we can see that the ABC has a core function that includes innovation, and the board has a duty to ensure the functions are performed efficiently. And that's really a clear indicator that we can pursue AI in the context of how to improve content delivery, as well as how to improve efficiency in the way that we operate. And of course, we're talking about governance, so we remember that our governance framework must support the delivery of both. It must allow for innovation and ensure that work undertaken with AI complies with these fundamental operational rules and does not undermine the core asset, which is trust. Every governance decision we make about AI is ultimately a decision about whether we are protecting that trust or eroding it. And of course, just try and move to the next one. Perfect, thank you. Of course, opportunities always come with risks. We want our governance framework to include appropriate controls for those risks. And let's take a look at these before we look at the framework for how we govern the use of AI in a way that manages these risks. We can't, of course, unfortunately, eliminate them. There are 6 listed, but I just want to focus on 2 of them: editorial integrity and workforce management, because I think from a governance perspective that these are the 2 most important risks. Editorial integrity, this is the one that has the most potential to damage trust. It goes to the heart of the relationship with the audience. And workforce management, we need to equip our workforces with the skills to use AI in a manner that promotes the objectives of public media and respects the safeguards in place, and inculcate a deep understanding of the meaning and role of human oversight of AI. We need the humans to manage AI and not the other way around. I've spoken about the 2 sides of AI for public media, the efficiency gains and the innovation possibilities. We must ensure that our government frameworks support both. Next slide, please. Give it a go. Perfect. I'm just going to talk briefly about the broader legal framework as it can affect our corporate governance of AI, and also because last week Australia did a complete pivot. So on the 15th of July, Australia announced that it would create an Office of Artificial Intelligence reporting directly through to the Prime Minister's office. And the purpose of this was to allow a consistent and central approach to AI across the country, with the work of various different departments that have currently been working on AI being brought together under this central office. The biggest change is the move away from non-mandatory guidance materials to legislation, which is proposed to be introduced in early 2027. There is significant interest from some of the larger AI operators to establish data centres in Australia, where, as many of you know, there's almost infinite sunshine to power the data centres with renewable energy. At the same time, Australia has said that the AI companies will need to comply with standards. They need to earn their social licence to operate. We know that one of the major points of contention with the AI companies is the Australian position on copyright. We don't have a text and data mining exception for AI. And the Prime Minister has flagged that the work of journalists and creators would be protected. And I've just got one of the grabs up there from him. Australian writers, musicians, artists and journalists must retain ownership and control of their work. So next slide, please. Perfect. Here we'll have a look at an overall corporate governance framework as it relates to AI. And as you'll note, it's the possibility of extending the existing governance framework. Some organisations will be well advanced in setting their AI frameworks and others less so. Either way, you will have existing frameworks that can be extended to govern AI. This is an example of one framework. Your frameworks will depend on the structure of your organisation and your governing rules. This is broadly the model at the ABC, but not the exact one. And the ABC is a creature of the Australian Parliament, so our rules of operation are quite clearly defined. At the top, we have the board that's setting the AI strategy, a plan for how the organisation will use AI to deliver its objectives while managing risks according to its stated risk appetite. The next level down, we have the executive leadership, the enablement level. Increasingly, corporations are choosing to have a designated chief AI officer to run everything through one consistent point. At that level is the policy ownership and the coordination of the cross-functional response. For the ABC, this is where our AI principles sit. Next level down, editorial and operational governance. This is the layer where you would see specific guardrails for the nature of the AI use, reflecting the need to provide guidance to the workforce on the specific use of AI for their work. For the ABC, this is where the usage of AI tools and protection of ABC data standards sits. Next one's fairly straightforward, legal privacy and compliance. So AI obviously has to comply with the law and any other applicable regulations. And below that, the technology management, the management of the AI tools, the approved tool register and vendor management. Next one, please. This slide gives the governing body the full internal governance stack for an AI use case in one place, from strategic intent down to operational monitoring. It's the practical operation of the previous slide. It's a cascading approach from the board settings at the top to the completion of the review cycle at the bottom. I'll just run through it from top to bottom. So the AI strategy, as I mentioned, will set the overall direction and objectives for AI use for the organisation. Underneath that, we have the AI risk appetite that tells the organisation how much risk it can take with AI implementation. For example, an organisation might have a very low risk for inaccuracy in content, but a higher risk tolerance for experimenting with AI to achieve operational efficiencies. The AI principles have been set to provide guidance across the organisation for AI use. After the top three items, we are looking more at implementation of specific projects or use cases. So now we start to look at things like prioritisation and resourcing. Is the identification of the proposed use case and prioritisation of that use case within the strategy? And then data integrity. The data outputs will only be as good as the data that is used by the AI tool. It's necessary to ensure that data used by the AI tool is accurate and accessible. It needs to be a fully curated set that excludes outdated material, and I'm referring, of course, to internal use there. And the workforce. What does the workforce require to successfully deliver the AI project? Is there sufficient resourcing and training to understand what they can and cannot do with the AI tool? Impact assessment. Has a legal and regulatory assessment been conducted? And monitoring. Once you have started, what monitoring is in place to assess what has gone right and what has gone wrong? Is there a process to log and review incidents? And benefits. I think, Aswan, you spoke about this, but at the time of commencement of the AI project, no doubt benefits were anticipated. They may be financial or non-financial benefits. Either way, is there a process to review the benefits realisation and decide whether to continue? And then next one, perfect. And then these are just 10 suggested governance guardrails for AI within an organisation. They're implementable controls, not aspirational principles. So 1, the approved AI tool register. You cannot govern what you cannot see. If a tool is not on the register, it's not approved for use. Define what the human is empowered to do and not do. Be careful about the word review if you mean approve, i.e. if you mean read, understand and make a decision rather than just review. This is the single most important control. Identify where the human oversight and accountability lies and be specific about what is expected of the members of the workforce. For data input controls, tell staff what sensitive or equivalent material can be submitted to AI tools. And again, be specific so they know where the guardrails are. Develop AI principles or rules to govern the use of AI and enable delivery of strategy in a manner that's consistent with risk appetite. Conduct a data governance review to determine whether data is accessible, curated, searchable, and old data is removed or tagged in a way that indicates it's no longer current. This is going to produce far more accurate outputs. Create an AI incident register, log errors, near misses, complaints, report to the board or equivalent oversight body. This is how you'll demonstrate accountability with the use of AI and that your framework is working and not just written. Don't forget a privacy impact assessment. You may need one depending on your particular circumstances or applicable laws. And workforce implications. Implement clear guardrails for the limits of AI use by staff. For innovative use cases, they may warrant an independent review before deployment. So if you're doing something particularly complex or innovative, you might need to think about what extra guardrails to put around that process. And then finally, an annual governance review at board or equivalent level. The technology is changing fast. Continual review of the framework and its effectiveness must keep pace to ensure that the governance remains fit for purpose. And next one. Great. These are just my personal observations over the last month or so of things that have been quite compelling and have resonated with me. They're operational lessons that support governance architecture, not additional obligations. So the first one is data governance. And the point here is that AI adoption doesn't create a records problem, but it will expose one that already exists. If records aren't well organised, that becomes visible very quickly once someone asks an AI tool to work across them. For example,
sorry, Jacqueline, you have 1 minute.
1 minute?
Yeah.
Thanks, that's on. In terms of inputs, staff need to understand what they can and can't put into the AI. So you need clear guardrails. And in terms of outputs, it's a really important lesson for staff and important for them to have guardrails. If you don't have the expertise to independently assess whether an AI output is right, you're not in a position to safely use the AI for that purpose. A plausible sounding wrong answer is more dangerous than an obviously wrong one because it won't get caught by a non-expert reviewer. And finally, on the complaint side, just to note that whilst people are fearful that AI will do away with jobs, I can confidently tell you that our complaints have increased very significantly over the last year, largely driven, we think, by AI and the use of AI to send in complaints. So there's an increased workload there. And then just one final slide, just some takeaways. And the first one's probably just the most important. The use of AI is a governance, trust and accountability question, not a technology question. And I might just skip to the third one. Humans are probably the weak link. As we see often in cyber incident data, it's the human who clicks on the phishing email. So we need to have frameworks that clearly identify how our workforce can use AI and any limitations that are appropriate for the particular use context. And fourth, just start in terms of getting your governance framework going and look at how you can extend or supplement your existing framework to support AI, and then make sure you continually review because things are changing quickly. Thank you very much.
Thank you, Jacqueline. Certainly interesting perspective you presented. Now let's hear from Mr. Alex Reza, Director of TV Programming, RTM.
Okay, very good afternoon. I hope you had a good lunch and ready to actually listen to some more talk. So since morning, we've been talking about AI, which I think for all of us has become, we are gaining our dependence on it. It has become a tool that we use in our work, and whether it's for AI-assisted content or AI-generated content. Okay, so my topic that was given to me is protection of children in AI-driven media production. But before I get into that, I would just like to inform you. Oops, it's not working. Next. Okay, we have an act in Malaysia which is called the Employment of Children and Young Persons Act 1966. It's a guide for permitted work, operating restrictions, legal protections, and penalty framework for children and young people. Next. So when we say a child, it's for a person under 15 years old, and for a young person, it's between 15 and 18. Why I'm talking about this is because the topic that I'm going to touch on is on content for young, AI-driven content for the young people. And next, please. Next. Next. Okay, but the current act is actually more on the physical side, because it deals with the Machinery Act, the Occupational Safety and Health Act, and Electricity Act. It has not touched anything on digital, because back that was 1966. Next. So next. So now that we have AI, so what I'm going to talk about is the digital shield and accountability, because we got to have a fundamental shift in how we protect children in a modern digital age. Because for decades, the laws focus on physical spaces, factories, studios, and communities. But now the most dangerous media production pipelines no longer exist in physical studios. They exist in a digital cloud. So what I'm trying to propose is we must shift the burden of child protection away from user and parental vigilance and place it firmly onto structural corporate liability. Next. Okay, so let's take a look at this AI media threat matrix. On the upper left, we have got deepfakes and cyberbullying, which is actually the rapid face swapping used to target individual minors among peer groups. And on the right, AI-generated CSAM, synthesizing hyper-realistic exploitative images using non-existent or real children. Third, the voice and identity theft, harvesting voice clips from social media to orchestrate targeted extortion schemes. And finally, algorithmic profiling, predictive engines tracking behavioral microsignals to keep children trapped in addictive loops. Next. Okay, in Malaysia's case, this is the evolution of child protection laws. The first, the Physical Workplace, the Children and Young People Employment Act, which I touched on just now, that it's more on regulating work hours, the physical safety and basic labor rules for children and young people. Then in 2001, the Child Act was expanded to protect societal welfare, focusing on family life, rescue mechanisms, and UNCRC alignment. But today, last year, we introduced the Online Safety Act 2025, where we enter the digital arena. Here, the scope covers things like algorithmic exposure, burden shifts to global tech platforms, and statutory penalties that reach up to 10 million ringgit. Next. Okay, we also have what we call a National Child Policy Vision 2026 to 2030, which is a policy from the government which focuses on 4 pillars for children: survival, protection, development, and participation. Survival meaning we want to ensure the 100% legal identity registration and the digital health integration. And for protection, establishing multi-agency digital dashboards, linking law enforcement, which is the police, regulatory authorities, we have our commission, and social welfare, the Department of of social welfare for real-time threat tracking. And of course, in terms of development, we are scaling psychological early intervention programs in schools and the participation to create child-led digital safety feedback councils and integrating regional forums like ASEAN ICT Forum. So the core principles in this is, the first, the best interest of the child, family-focused approach, and non-discrimination. And the action plan is on things like cybersecurity, protection against abuse and exploitation, focusing on mental health and holistic development, and the governance and accountability. Next. So we have a 4-tier cyber response strategy, which is prevention, centralized identity verification. We have something what we call My Digital ID to create verified age gates, advocacy, school programs teaching digital resilience and grooming recognition, intervention, rapid response networks linking hotlines, cybercrime divisions, and internet and ISPs for tracing. And finally, support, specialized psychological rehabilitation for victims of digital abuse. Next slide, please. So when we take a look at this, you see on the left the Online Safety Act 2025, short form as ONSA, which is the legal foundation forcing tech platforms into 10 million license liability. And under the ONSA, we have 2 codes. The first is the Child Protection Code and the Risk Mitigation Code. The message here is clear that the primary burden is no longer on parents monitoring screen time. It is on tech platforms also to engineer the safety by design environments. So the Child Protection Code, it's a subsidiary instrument. It was just recently introduced on the 1st of June 2026, and it forces the digital service providers, ones that have 8 million users, to actually register with the government. And what it says is for people, they won't allow people who are under 18 to register on the apps, and mandatory government ID verification, and the platforms have to practice algorithmic detection, default privacy, algorithmic and parental, and also a parental dashboard for parents to actually monitor what the children are actually watching or consuming online. Next. So 8 million, the deemed licensee threshold applies automatically to any social media or messaging platform with more than 8 million users in Malaysia. And it was not easy actually to get this thing operationalized because there was some resistance from platforms, but we have to think of the children. We have to think of what our people need. And so we decided that 16 is the age, and we made it sure that they have to comply with this legally. And priority harmful content, which is the child sexual abuse material and financial scams. And the mandates are immediate, dynamic, and there is a permanent removal when it's detected that the content is harmful. Finally, the general harmful content, cyberbullying, obscene material, and content that disrupts public tranquility or accepted cultural behavior. Because cyberbullying is something that is quite urgent in Malaysia, and ONSA is trying to protect and take care of that. Next. To protect minors, we mandate a strict age verification pathway. They cannot just simply rely on self-declared birthday checkboxes. The age must be validated against official government records, meaning under 16, absolute block from independent account creation, and for the ages of 16 to 17, account defaults to top-tier privacy, harmful media filters are forced on, and direct messages from adult strangers are blocked by default. Next. So algorithmic filtering and moderation. Content streaming into feed passes through 3 mandatory algorithmic filters before reaching a minor screen. The first filter, the CSAM detection, proactive sweeping and quarantining of explicit material. Filter 2, synthetic media labeling, automatic identification and prominent tagging of AI-generated manipulated media. Filter 3, anti-grooming AI, pattern detection, targeting predatory text behavior and manipulative gamification loops. Next. So the risk mitigation code, that's the governing architecture. Platforms are required to maintain 3 structural pillars. The first, mandatory annual audits, certified internal risk teams must audit algorithms and submit safety reports directly to corporate boards. Second, verified advertisers to present scams. Ad placements require government-issued corporate or individual verification. And third, deep fake identification, an infrastructure to automatically label synthetic media. Next slide, please. So time is critical when addressing online harm. When priority harms such as grooming on CSAM are flagged, for the first hour, mandatory official acknowledgements by the platform, and 1 hour takedown window, complete permanent removal if confirmed, and the 24-hour temporary takedown during extended review. And the failure to meet these countdown windows trigger an immediate ringgit fine, accruing an additional 100,000 per day until the matter is resolved. Next. The MCMC legal pipeline. MCMC is the Commission for Multimedia and Communications. So the enforcement follows a clear 4-level pipeline. The first level, detection and demand for internal algorithmic logs. Level 2, voluntary undertaking, which is a binding opportunity for platforms to fix engineering failures. Level 3, the 10 million civil debt recovery, recoverable directly without requiring a lengthy criminal conviction. And level 4, piercing the corporate veil, meaning holding directors and chief compliance officers personally and criminally liable. So just to give you a brief update, from the 1st of January to the 1st of July, 345,712 messages have been taken down within a 30 to 45 minutes window frame. And 91% of these are actually gambling ads or scams. Okay, in order to do the answer, next slide, with our legal team and the policy team actually did global benchmarking and comparing with international counterparts, Australia and United Kingdom. So you see Malaysia and Australia has the 16-year-old age, and age verification is mandatory. And primary enforcement mechanism for Malaysia is hourly takedown clocks and civil debts, and the maximum primary fines is 10 million for Malaysia, Australia $50 million.
Sorry, Alex, you have
UK,
1 million?
18 million or 10% of global turnover. And my final slide. Next. So the AIGE, the AI Governance and Ethics Guidelines, which was developed by two divisions in Malaysia. One is the Ministry of Science, Technology and Innovation, and also the NAIO, the National AI Office. They establish core ethical boundaries, reliability and control, where there's audited parameters for educational and entertainment AI, data minimization, which is strictly prohibition against logging youth geolocation or biometrics. The third, child-centric guardrails, mandatory shutdown of AI chatbots exposed to self-harm or abuse prompts. Well, at RTM, we are developing guidelines actually on AI in terms of to take into consideration the social, economic, and legal aspects. And well, to complete my presentation, we cannot protect the children of tomorrow using the laws of yesterday. Protecting youth in an AI-driven media landscape requires holding structural code accountable. A child's digital identity must be safe by default and not by chance. Okay, thank you very much.
Thank you, Alex. Another interesting topic. Next, we have Ms. Ashwini Nathasan, who will be speaking about data governance for ethical AI governance. Over to you, Ashwini. By the way, she will be presenting remotely.
Good afternoon, everyone. I hope you can hear me.
Yes, we can. Go ahead, Ashwini.
And I also hope you're able to see the slides.
No, at this moment.
Not at this point. Okay, let's try again. Does it work now?
Yep, we can.
Okay, great. Thank you. It's a great pleasure to be here, and it's also my deep regret that I'm not able to be there in person to make this presentation. I want to thank ABU for this opportunity, and particularly Dr. Seemantani, who's been excellent in making sure that I was able to be a part of this. So thank you so much. On that note, I want to jump into my presentation on data governance for ethical AI governance. In some aspects, what I want to say is today's discussion slides have overlaps with what we have discussed in other sessions today, and I was able to listen to a few of these excellent presentations. But I want to talk about this from the lens of data governance as opposed to only looking at it from a copyright or from a data protection angle. So I'll jump into that on that note. When it comes to discussions around AI and copyright, there's always an understanding on both the input as well as the output layer. But since my presentation is going to be on data governance, I'm only going to look at it from the point of view of the input layer. And I'll also be touching upon data governance from the point of view of open data, right to information regimes, data protection legislations, etc. And to finally draw this linkage of how important data governance is to establish ethical AI governance. What do I mean by data governance? Before I jump into the slide, I must say that this is a part of a larger study. This is a study that was done in 7 jurisdictions on data governance in both South Asia and Southeast Asia. What are the countries? You're going to be seeing it in a minute. There was also a mini study on South Korea. I led the study for Sri Lanka. And there is a regional report based on the studies conducted on data governance frameworks in all of these countries in South Asia and a few in Southeast Asia. I'm happy to share the report for those who are interested in learning more about what we did with the study. During the study, we looked at what really is data governance. And when we talk about data governance, we are not looking at individual organizations or corporate data management. That is one of the ways to define data governance, but we are looking at it from the point of view of state regulation, policies, and practices. And some of these areas that have been included within the scope of data governance relate to right to information, open data, official data, access through statistics and census reports, privacy and data protection, cybersecurity, data localization, and of course, copyright as it intersects with data and AI use. Obviously, this is a very big report spanning to over 100 pages, so we won't have time to look into every aspect of it. I'm going to narrow it down. But when you read the report, you will see that data governance has been considered from the point of view of increasing access and decreasing access. When I say increasing access, decreasing access, I'm going to speak about those legislations or regulations that increase access to individuals and those that decrease access to individuals. Now, I must say the increase and decrease have not been looked at as value judgments. We are not saying that those that decrease access are particularly in poor light. That's not the case at all. We are looking at it from the point of view of those that decrease access because we ought to decrease access in certain respects. So this is in no way a value judgment. Let's look at right to information law. Now, when it comes to the right to information law, there have been laws in all of these countries, and these are the studied jurisdictions of the study, which I said I'll come back to: Philippines, Thailand, Indonesia, Pakistan, Nepal, India, and Sri Lanka. I led the study for Sri Lanka. So when we look at the RTI scores, we noted that on paper, all of the countries had a right to information legislation, but how those information access laws or the freedom of information laws translated to practice with what was the varying factor between these countries. Your question may be, how does this relate to AI governance? One of the fundamental principles of AI governance or ethical AI governance is explainability and transparency. Yes, there can be laws that mandate it, and we had an excellent presentation by Ms. Galina, who mentioned about Article 50 of the EU AI Act on transparency. In countries where there is no such legislation, the right to information law can be the mechanism, can be the tool through which access to information can be obtained. And this access to information can extend to how AI is being used or how AI models have been trained. On that note, on AI and copyright training, on AI for training data, how AI is being used for training, and also copyright protection. So what if training data that has been used is copyrighted material? Can they still be used? I know there were presentations about this earlier today. I won't be going into detail, but this slide will give you a framework about how this has been looked at in different jurisdictions. Most of the countries don't yet have a data or text or data mining exception, as should be the case if there should be a free training of data, even of copyrighted material. But even in the absence of a TDM, as we call it, text and data mining exception, whether fair use exceptions can be used for that purpose. That's the next question that comes in, but these have not been tested through judicial interpretation, through case law, so we don't know yet. There's one case law that's pending in the Delhi High Court in the Indian context, and we have similar such examples elsewhere. But what we need to remember is where AI training is being done with copyrighted material, it cannot be done unless either there is an exception or there has to be other justifiable reasons. But right now, how companies are operating are because of the legal lacunae. The legal lacunae means that they are able to get away with this because there is no stringent provision on how it can be done, or if there is a requirement of licensing, etc. This legal lacunae has enabled companies to train all material available publicly, including copyrighted material. Similarly, the question comes to when there is copious amounts of data that are being trained on, and such data also includes personal data. Will that be covered within the realm of a data protection legislation? That is the question. Now, just because there is a data protection legislation, it does not mean that there will be protection for training data that has personal data. That is no reason. That depends on certain factors. But this is a snapshot just on the existence of a legislation. Is there a legislation or is there no legislation? But I want to stop here and mention a few points. Just because there is a legislation, like I said, there is no reason that personal or sensitive data that is available online will be protected through a personal data protection legislation. What it requires is, A, whether the legislation talks about publicly available data. Is publicly available data included within the scope of personal data protection legislation, or is it outside the scope? Since the country that I work in is Sri Lanka, I'm going to take the Sri Lankan example, the Sri Lankan data protection legislation as an example for this. When there is training of vast amounts of data, including personal data, what is the scenario? Under the Sri Lankan law, just because it is publicly available data, there is no exception to the obligations under the Personal Data Protection Act, which means that the obligations of consent, including notice, etc., will apply. Now, in the context of a huge data set, or when there is going to be generative AI training that's being done, this individual level compliance will not be made possible. So the next question is, can this be made possible through other lawful basis for processing? And usually the answer is there a particular clause that refers to legitimate purposes for processing? That is, we call it as legitimate processing or business interest-based processing. In Sri Lanka, yes, legitimate reason for processing is one acceptable clause through which businesses are able to use as legitimate interest. So training data could be considered as coming within that exception, but it's still not very clear. What we need is clarity on how personal data will be dealt with when personal data is used for AI training purposes. That is another legal lacuna that we have and that we need to fill in many countries. For instance, in Japan, they are moving ahead with a clause through which there can be processing of personal data, and that processing will be considered as legitimate interests. So that's something that countries have to consider when they are looking at AI governance, and AI governance not just at an individual scale, but at the scale of the state as a whole. So what really is the objective of my presentation? It is to establish that AI governance is not really a new field because we are building it on data governance. There are several aspects that are crucial to data governance, and I'm going to focus just on three, the two that we have already discussed: data protection legislation, copyright and text and data mining rules, and thirdly, right to information and freedom of information regulations. Why are these important? When it comes to data protection law, it provides guardrails for personal and sensitive data as may be used when they are being used to train AI models. Secondly, right to information and freedom of information legislations, they provide the impetus to transparency and explainability. And finally, copyright, because we really need to know how copyright will be considered when the training data includes copyrighted materials. And I believe together we are able to build an AI system that is trustworthy, lawful, and locally accountable. And there are also these trade-offs that have not really been resolved in the region or in the studied jurisdictions. It's the questions on accountability and secrecy, or innovation and protection, in resilience and openness. So these are open questions that we're still grappling with. But the starting point is to realize that these are the trade-offs that we have to essentially look at. The other point that we wanted to establish through this study was to consider whether countries were learning from each other or they were looking at models in the EU, for instance. And that's been referred to as the Brussels effect. We were not really able to see many examples of how countries were simply copy-pasting regulations from others or from the West, for instance. But there are some legislations that mirror the EU example. For instance, the Sri Lanka data protection legislation models after the GDPR style one. But what we found essentially lacking was the countries learning within themselves, how they were looking at examples in South Asia and Southeast Asia. There were some examples, but not so widespread. And that's something I believe that we really need to work on. And initiatives like the ones that we are doing through ABU can be the step forward. So I'm just going to wind up in the next couple of minutes, but then when we look at the 6 pillars for rights preserving, innovation enabling data governance vis-a-vis AI governance frameworks, these are the points that I want to leave you with. And what are my practical takeaways? Essentially, the first question is, where does your data sit? Secondly, to push for clear text and data mining regulations. Third is to consider regional coalitions and not just ones at a national level. And the last point being transparency really as the leverage. And I'm glad to see that how presentations throughout the day went into great detail about how essential it is. On a concluding note, instead of leaving you with just answers, I believe that these are the points that we can all ponder. Where really does our national data governance framework help? Is it blocking any innovation that we may have, or is it really enabling responsible AI use, including when it comes to broadcasting of content? How are we looking at copyright exceptions, and is it keeping pace with our requirements of today, including openness and also ones that need to be privacy respecting? And finally, what is the role of ABU-like regional organizations when it looks at AI governance as a baseline? And how can we look at it and how can we consider them? So on that note, I want to stop my presentation. I don't want to go beyond the time that's allocated to me, but I hope there will be questions and I hope that we can engage further on this. And once again, apologies for not being there in person, but I've put my LinkedIn ID here and I'd love to connect with any of you if you'd like to chat more on this. Thank you so much.
Thank you, Ashwini. I really like your last sentence there. Can you repeat that, your last sentence there? What would be something to do with ABU there? Can I see it again? Your last? What would a regional ABU-led data and AI governance baseline look like? That is a very, very powerful question. So we have approximately about 15 minutes for Q&A. So I would like to open the floor for any questions. Anyone? Or I should start myself. This is for Jacqueline, since you're talking about governance. Like for any broadcasters, like that are starting their AI journey, right? For example, like smaller broadcasters with very, very limited budget. So what will be the 2 or 3 elements that they should implement first?
Thank you. I think as I was talking about, most of us will have existing frameworks and I think they can be extended. So starting with what you've already got, I think makes sense. And then seeing where you can add on to cater for the particular AI enablement that you're interested in doing. And I think secondly would be building the staff capability to manage AI, to understand how to use it, understand how it can be used to improve efficiencies, and understand the guardrails so that they can understand the limits on what they can do with it in the workplace. But I think the key thing is to just start and work with what you've got, because I think it's an exciting ride for all of us and we all just...
refine it as we go, as you say.
I think we are actually, because it's happening all around us, so we need to just use the frameworks we have and extend them as we can and as makes sense and suitable, appropriate and ethical.
Next question, anyone? Or I should ask again. No? From the floor? Good.
So this is a kind of a very general question to all of you, and because now there are, Alex from Malaysia and Jackie from Australia, and of course, Aswan and Simantani from Malaysia as well. Alex made a presentation about a kind of, measures to protect children, younger generations from, kind of a misuse of AI, I think. And this movement is actually sort of spread out universally, like when we think about Europe, for example, and Alex's presentation showed the case of UK as well, but not only UK, but also other European countries as well, like, if I remember correctly, France or Spain. Do you think this movement is going to spread out? Because, I also hear that, this is kind of ideal for in terms of the regulation, but when it comes to the operations or practices, for example, of course, people will be able to tell a lie about the ages, for example, and Malaysia will be probably, they're trying to, probably make sure that they will connect with the data about age with the for the verification. And do you think this kind of measure is sort of, do you think it is going to work in general?
Okay, thank you, Harusan. Okay, we just started that in June, so for me to say whether it's going to work or not, I'm positive that it will work, but how far it will work, I think remains to be seen, because I think we can see maybe in 3 months' time how many more takedowns and on what basis they'll be taken down, and maybe in another 6 months and in 1 year. Because I think every country has its own sovereignty, and every country, although we would say these days that children are very generalized, but I think the needs and the dynamics of each country is still different. What may be the needs of Malaysian society may differ from Japanese society maybe, or African societies, or European societies, or American societies. So I think primarily we have to start somewhere, and that was the first start for Malaysia to tackle the whole issue, because you cannot stop technology. AI will definitely develop. We used to talk about generative AI, but now it has advanced to another level where it can start thinking for itself, and we don't know what's going to happen maybe next year or even in the next month. But we have to make a start somewhere, because if not, we'll just be thinking, we'll be talking discourses, we'll be talking hypothetically without taking any actions. And of course, plans of action that we take, although we usually generalize them into short-term, middle-term, and long-terms, may still have to be amended and be responsive to the changes in society, to changes in the dynamics of the world, for example. Let's say you have this identity thing, right? Although that's one attempt for Malaysian government to have identification. But I'm not sure if all countries in the world require things like identification cards. Like Malaysia, yes, we have our IDs, but I'm not sure how many other countries still practice that. And so that's also a factor that we have to take. It's how to identify, and how to identify that the person who's actually attempting to go online or on board the platform is that particular person, or it's somebody impersonating. And now, you have the use of VPNs that can actually deter people even in places. So things are developing, and that's why we have the Ministry of Science, Technology and Innovation, we have the National AI Office, and several other governing bodies in the country to look into things and address them as swift as possible. And of course, when we talk about laws or guidelines, it's not a matter of one particular agency. You have to have public engagements, because there may be people who may talk about, for example, the freedom of speech, which is one issue when we had that, and the right to information, as was that was asked by Ashwin just now. So things like this are always being considered, but I think whatever it is, we have to make the first step if it's a baby step, at least it is a step. Like you said, like people say, a journey begins with a single step. So that's one thing that we're going into. And we are actually considering what other people are doing, because we don't want to be isolated by ourselves. Because kids will grow up, information is at their fingertips. And even though there's parental thresholds, when the kids grow up, they have their freedom. How do you control them? So things like getting them cultured to a responsible use of AI and all that has to begin.
Next question. Yeah, we got Tom.
Hello. Aswan, I've been listening to this from the morning, and also what the ABC perspective, also from RCM, two of the bigger players in the region that we deal with. And coming back to you, Aswan, in your presentation, it's not a question, but it's just a thought to get people probably thinking, probably these are the newsrooms, etc., that are smaller. Is it time that your yearly budgets that you prepare includes this aspect of what we've been discussing? Because we can talk about it, and what Alex mentioned is very true. We have to, it's there. You can't deny it, you can't avoid it, you can't probably, ignore it. But from a financial aspect, from a financial point of view, probably it is time that our yearly, if it's not already being done by most, is have budgetary allocation to be able to achieve these things or protect our broadcasters, individual broadcasters or newsrooms or content creators within the circle. I mean, that's what I think. I could be wrong. The finance expert is there. But I think if we don't, we probably will end up plucking funds from other aspects of the business and trying to achieve something which in fact is also impacting that other areas of the business. Just something that came to mind. Thank you.
From my perspective, very, very interesting, Indra. Thank you for the interesting question. From my perspective, we should include it. Because at the end of the day, we have to go back to the basic. What are we trying to achieve? So once we are clear on what we want to achieve, then comes the question, how are we going to achieve it? So your question, I think, comes from in the how. So, because what management or the stakeholders wants to see is basically the end figure. So how do we see the end figure? We need to have all the right information, correct? So if we are reporting a half-baked reports, for example, so if we are not including any certain expenditure that we think of including, so we won't be able to actually, find it.
Sorry, just to add, I'm not only talking new AI tools that are coming out in the market. I'm talking about legal. I'm talking about, training needs, legal side, AI side, all that inclusive. Which too often I've seen whereby companies just totally disregard it. Then all of a sudden, in the 7th month of the year, you are running to the financial controller, asking him for some money.
Yeah. That happens like 90% of the time. And it requires special requests, isn't it? But it's always good to plan. It's always good to plan, and I always believe that if you fail to plan, you're planning to fail. So that's my view on it, unless the rest you have anything else to say.
Yeah, I do agree we have to plan, and I do agree budget should be allocated for that. But when you talk about national budget in Malaysia, for example, we get our budget tabulation in October. So sometimes we don't know what the Prime Minister has to say. So on that particular day, on that Friday in October, we will listen and see where he's focusing. And AI is something that he's very serious about. Malaysia, for example, that's why originally AI was under the Ministry of Science and also the Ministry of Communications and Multimedia. And then it was divided, that it became its own ministry, the Ministry of Digital. And the National AI Office, the NAIO that I mentioned just now, is actually under the Ministry of Digital. And they look into things. And in terms of budget, when you're a government staff, you have your government email, for example, which is under Google, you get the facility for using Gemini AI. And then, for example, if you go training under, let's say, a university, I went for training under one university in Kuala Lumpur, and what they did was, when you became a student, even though it was only for 3 days, they gave you a free professional account for ChatGPT, meaning they are actually getting you used to the idea that AI is something that you need to do, but they will teach you how to use it responsibly. For example, now these days, if I look at my friends, they enjoy using AI, but to make posters, to make funny videos and things like that, which for us who are content creators and we are serving the public, that may not be something that we should strive for. But you should use AI responsibly, which I think most of us have used in our presentations from morning, because we want to find out how to do things. And I think that's something that is important, because sometimes certain vocabularies don't appear in our minds. For example, I'm a producer, and basically, IPLC is more on the legal side, but of course we have a certain knowledge of legal, but I may not be as fluent as Dr. Seema, for example. She's been there for so long, and that's been a study. So using AI is something important, and I think our government is very serious on that, and that's why they are exploring and they're finding new things, and at the back of their mind knowing that it has to be sustainable for the people, and yet has to be agile and flexible to accept new things coming in.
Indra, can you pass the mic behind? We have one more question.
Thank you for the opportunity. I have a question for ABU. So TVR has been a member of ABU since 1983, and we are one of the 7 founding members in Asia Vision since 1984. So my question is, should ABU develop a roadmap policy for AI for its members so that we can have a roadmap for all the ABU members? Thank you.
Thank you. I think the technology department at the ABU has recently launched an AI site for the members. It's a work in progress. It's not perfect, but I know when Dr. Vaisal was around, Director of Technology, he had initiated that. So there's a site which we can share with you. And of course, input with the likes of yourselves and the other members will help us better. But it's an idea that came, I think, some years ago. And it's finally started it took off, and it's there now. Thank you.
May I be cheeky and ask a question, since our colleague from TVRI has talked about the roadmap for concerning AI, right? And as I mentioned, our government has actually sponsored us using Gemini and ChatGPT. Will there be anything in the future planning, maybe Mr. Azwan, Dr. Seema, or even Indra, that ABU can provide some kind of facility for AI for members?
I can speak from the news perspective, because the other departments I'm not so sure, but we have been talking about it, because, and I think it's not only about established members, I think the smaller members as well that we have, or that I keep on mentioning about, they are easy in need. So from the news perspective, yes, I can give you a little win that I had when I started a year ago, is we managed to convince to get Gemini for our newsroom team. And this is because when I walked into the office, the first question was, what tools do we use? We didn't have any tools at that time. not a paid version anyway. So it was on the website, whatever it was. So now we've started doing that to help in translations, which is of course very much specified if we use it. It's translated by AI, similar to EBU. So from the news perspective, yes. From the whole ABU perspective, probably at the GA you'll be able to ask that.
That's why I say I'm just being cheeky.
So the ABU has launched its own AI guidelines, and these are not binding, but they serve as best practices for members. And for ABU to come up with any binding guidelines, it would really depend on the willingness of the members, because coming up with something binding requires a consensus.
Yeah, and I don't think if it's a binding thing, it would actually work well with the governments, because I think every country will want to practice its own sovereignty. And I think primarily, we will have to follow the roadmap set by our leaders rather than it. But of course, having an ABU guideline is good, because that would be useful for broadcasters, because I think the roadmaps developed by governments are very general. But it's great to hear that you're developing the guidelines for broadcasters.
Interesting stuff. Yeah. Okay, I think time's up for session 3. And thank you, Jacqueline, Alex, Ashwini, and Seema for requesting me to moderate this session.
Hello everyone, this is Esra from TRT, Turkish Radio Television Corporation. It's my pleasure to moderate this session. Thank you so much for this invitation for me. I am only one on the stage because our speakers will attend us online. So I will start. Welcome to session 4. Our title is Global Perspectives on AI, Digital Media, and Emerging Regulatory Challenges. Today we have experts from international organizations, academia, and public broadcasting institutions. If you are ready, we can start because I guess our speakers on their screen and they are waiting us. First of all, I will start with Dr. Murray Green. Our presentation is Platform Regulation and Enforcement Trends Across Asia Pacific. I would like to tell something about Dr. Green. He is international media law advisor and also academic with extensive experience in platform regulation and communications law across Asia Pacific. I'm not sure, is he ready or not?
Ezra, thank you very much. Can you hear me?
Yes, we can hear you. Mr. Green,
very good,
welcome.
very good.
Welcome to our session.
Thank you, thank you. Thank you very much for your kind introduction. And greetings from Melbourne, where it's winter and it's very dark. So the sun is still shining, I think, in wonderful Jakarta. Even though remotely, it's a great pleasure to be back in the company of Radio Republic Indonesia and the ABU IPLC. I've got very fond memories of working with former RRI director Pani Hardy. I traveled with him in his business car and got a very quick introduction to Jakarta traffic. Pani was such a practical person, his front passenger seat sprung back to lay flat, and he very adroitly positioned himself in a way that he could have a nap on the very substantial journey to his next appointment. RRI has always been very resourceful, and Pani certainly led the way in relation to that. And the IPLC also has had some ongoing and very significant impact on member states as we wrestle with the regulatory impact in a fast-changing media environment. And today, what I want to do is to note the nature of that change and identify some regulatory initiatives in the Asia Pacific that are shaping major reform in media accountability. Our focus will be on the shift in audiences and audience behavior from free-to-air broadcast media to online delivery. Now, I've got a PowerPoint, but I won't share it with you because it'll be available from the Secretariat later in the conference. And it just gives you the references that I'm going to allude to in my brief comments. Over 10 years ago, I undertook a study for UNESCO into the development options for public service broadcasting and community broadcasting in the Mekong. And the report looked at media environments in Cambodia, Laos, Thailand, and Vietnam, and Singapore was the reference point by way of contrast. There I see the PowerPoint. So if we can just flick through to slide number 2, that'd be great. One of the things that became very clear when I was doing the study was the durability of the 2008 UNESCO Media Development Indicators, the MDIs. And they had 4 core category areas. Now, if whoever's manipulating the slides for me, maybe I can do it myself. No. Anyway, these are all outlined in the slides. In slide 2, there are 5 key areas that the MDIs looked at and addressed. First was system of regulation, to look at laws, whether they in fact support regulators being independent and having the ability to foster freedom of expression. Number 2 was plurality and diversity of media, and to see if the public has access to many types of news sources particularly. 3, media as a platform for democratic discourse, to ensure all people have a voice in society and that news and the presentation of news is fair. The 4th element in these MDIs was professional capacity building to make sure journalists were safe and had standards of presentation and news gathering. And finally, 5thly, a technical and infrastructure capacity where media organizations had the ability to adopt new initiatives. So these 5 MDIs, even though created in 2008, seems a long time ago, I think they have some enduring significance in the comments I want to make. Now, this is really worth looking at in terms of the way we are facing quite a sea change. And it's forcefully demonstrated in the changing ways in which audiences are now accessing content. And structurally, this is evidenced by a separation, a growing separation between content makers and content distributors. So the split between who makes the content and who delivers the content. Used to be the same entity, now there are different entities in different parts of the world often. So what sort of pressure does this place on media regulation and media regulators? Among the foremost of current questions is that of regulatory jurisdiction. If content is produced in one nation and distributed to that nation's audiences from another nation, how far is the reach of a media regulator? let us look at the gravity of this challenge by examining the production and distribution of news. And I want to share with you some Australian work on this matter. PowerPoint number 3 is relevant here for those who've got access to it. The University of Canberra, UC, recently published the Digital News Report for 2026. And this work is part of Oxford University's Reuters Institute for the Study of Journalism and their research that examines news content origination and distribution in some 48 countries across 6 continents. The UC study found that social media is now the second most Australian news source behind television. Social media, 56%. Free-to-air television, 57%. There's nothing in it. So social media has even become the main pathway for online news websites. Some 32% of people are now getting their news from not newspapers or watching on screens in terms of free-to-air, but are getting it off websites. And even access to those websites is now coming through social media platforms. A pressing regulatory and economic issue is who creates and bears the cost of news content and who benefits from any income associated with it. On to PowerPoint 4. Now, there have been 2 major responses to this question in Australia. The News Media Bargaining Code, the NMBC, was established in 2021 under the watch of the Australian competition regulator, the Australian Competition and Consumer Commission, the ACCC. Now, this code governs the commercial relationship between Australian news businesses and the designated digital platforms who benefit from significant power imbalance. By December 2021, over 30 commercial agreements between digital platforms, principally Google and Meta, and Australian news businesses had been completed. And over the past 5 years, some $1 billion Australian dollars have been paid by the digital platforms to the news creators. Now, when it came to renew these relationships, Meta decided that they would not continue the arrangement and removed or deprioritized Australian news in its platforms. And so just recently, the Australian federal government has responded with a new code and a new provision, the 2026 Media Bargaining Initiative, the MBI. And this provides that larger digital platforms will now pay a levy of up to 2.25% of their Australian revenue unless they come to a deal with local journalism enterprises. Now, this arrangement is expected to generate something like between $200 and $250 million a year that would be distributed to local news providers. Now, you can understand that the reaction to this development created some hostile reaction from some of the players. A Meta spokeswoman said this initiative amounted to what was really a digital services tax. However, under the MBI scheme, the rate of levy can be reduced if individual commercial agreements can be reached with news providers. So if they can do the deal and it's acceptable between the news providers and the digital platforms, then the levy will not apply. Now, the NMBC and the MBI test was really a stretching exercise for the regulatory reach of national governments over the businesses of international digital providers who collect the revenue from content generated by national providers who bear the cost of production. That the NMBC worked, at least for a while, may suggest that with further consultation, there may be an effective way ahead, and news organisations are optimistic that this can be achieved. Now, online engagement does not only raise questions about the disconnect between who produces and who distributes, and appropriate means of cost and revenue sharing, but also concerns itself with online safety. Now, we've had some very interesting discussions so far in this gathering today that I've been able to hear part of, and I'm very impressed by the insights. Now, Australia, PowerPoint number 5, Australia is now a leader, or was a leader, in, and remains a leader, in legislatively engaging with child safety online. We've had a lot of discussion about this in the short time that I've been with you this afternoon. In December 2025, children under 16 were excluded by law from holding social media accounts. Let me say that again. Children under 16 excluded from holding social media accounts. Companies such as Facebook, Instagram, TikTok, YouTube, X, and Snapchat are required to put in place mechanisms to ascertain the age of users under 16 and prevent their access. Now, if the social media company doesn't get involved seriously in making this happen, they could face fines up to 49 million Australian dollars. Now, that 49 million is a large amount, but it's just recently been raised to 99 million. So there's no doubt about government resolve. But however, the effectiveness of these measures is open to question, really. A study by the University of Newcastle in Australia found that more than 80% of under 16s in the country were still accessing social media platforms after this requirement was put in place. Much of the verification was self-generated. You just said how old you were, and that was it. And that might be matched by the uploading of a face image, which would be tested for age. Now, this is requiring some further scrutiny, but the Australian initiative, which was a world first, has created a lot of international interest. And in our own region of the Asia Pacific, Indonesia, Malaysia, and Singapore are among the nations, as we've heard today, that have engaged with the reform in children's online safety. Indonesia was the first country in Southeast Asia to restrict children under 16 gaining access to social media. And that prohibition came into effect beginning from March this year, and is matched by evidence of some regulatory resolve. The Indonesian Ministry of Communication and Digital Affairs undertook a surprise visit to the Jakarta office of Meta recently, following concerns about harmful content and how it was managed. But the scale of the task in Indonesia to manage around 70 million users, that's 25% of the population under 16, is immense. But there's no doubt about the resolve. Communications Minister Matia Hafid recently told a news conference that there would be no compromise on the question of compliance. Now, as we've heard today, Malaysia has also developed explicit requirements into age verification to prevent under 16s accessing social media. Amendments to the Online Safety Act, effective from 1st of June this year, centre around rigorous means of age verification. Malaysians are far ahead of the Australians when it comes to this matter. My Digital ID or passports are means that are provided and only accepted as a proof of identity and age. The Australians need to have a look at this. Singapore has taken a different approach with an emphasis on a differentiation of safety standards. Recently, Digital Development and Information Minister Josephine Teo said that the same services can provide safe access for those under 18, while some services may not do that. And so rather than having a blanket approach, the Singaporeans are looking at developing differentiation. Restricting access is not where they want to start and not the preferred outcome. Now, there appears to be growing support for regulating social media use by young people, and the efficacy of verification methods of age and any substantial engagement by digital platforms appear to be remaining issues to be developed and resolved. This area of regulatory reform, though, is indicative of the challenge of jurisdictional reach, when major offshore corporations own and control national media use. We have just touched on the increasingly demanding issue of young person access, and I want to look forward to particularly hearing what Dr. Amo Panchahiwa has got to say after my presentation and in our session later today. And in closing, I just want to note some developments that are pressing regulatory issues that face nations of different scale in the Pacific. A principal resource in looking at the resources of Pacific media is the State of Media Report, Pacific 2025, published by the excellent work of the ABC, the Australian Broadcasting Corporation's International Development Group. 12 different countries in the Pacific were studied: the Federated States of Micronesia, FSM, Fiji, Kiribati, the Republic of Marshall Islands, Nauru, Niue, Palau, Samoa, Solomon Islands, Tonga, Tuvalu, and Vanuatu. I've worked in many of those places, and they're all great nations. But like any small nation or smaller nations, they have particular challenges. And the findings of regulatory significance in the Pacific include what are patterns that we've observed elsewhere. International internet access dramatically increasing, particularly in Fiji and Samoa, with internet access rates now of 85% and 75% of the nation respectively. Misinformation and disinformation as being major issues in terms of media content. Government funding of media enterprises both sustains and stifles media in some examples. And media freedom is a concern of many Pacific media institutions. And media self-censorship tends to be a characteristic of some of the smaller Pacific nations, where delightfully everyone knows everyone. And so when you are running news stories about your neighbors or your friends, there are different criteria often that kick in. The extent of government constraint of the media was amply demonstrated by Fiji's Media Industry Development Act, the MIDA, which was introduced in 2010 and repealed in 2023. Now, this original act was established by decree and then military intervention by way of the military government. And this significantly restricted media freedom and stipulated that almost all Fiji media had to be locally owned, and there were jail terms for those who reported or were judged to be reporting content not in the national interest. The repeal of the MIDA has now put in place an environment of self-regulation under the watch of the independent Fiji Media Council in Fiji, and media freedom has now been effectively restored. What I've attempted to do, this is the last PowerPoint 7, what I've attempted to do in these comments on platform regulation and enforcement trends across the Asia Pacific is to identify some key developments. And the Asia Pacific has undergone rapid change in media use. And my earlier UNESCO study seems a long way away, but the issues we were looking at, developing public and community broadcasting, still have the same sort of challenges that we've outlined in our brief survey this afternoon. But the media development indicators, which informed much of that study, still remain very durable. What is central to my comments today, in conclusion, is that media regulation must follow where the audience goes. And this can take us into some very demanding places, including testing our understanding of jurisdiction. And when there is a split between who the content providers are and who are the content distributors, this split is getting wider and a big challenge for all of us as we chart the future. Thank you to the moderators, Ezra, and our hosts, the impressive RRI, and our organisers, the ABU IPLC, under the great leadership of Mr. Haruyuki, and our go-to person of expertise, Dr. Simantani. Thank you very much.
Sorry. Thank you so much, Mr. Green. Your presentation is really significant to understand, especially Asian Pacific perspective for us. Please wait us. I guess our audience wants to ask some questions to you. Thank you again. Thanks for your time. And next time, next our speaker they are two, because of they are from WIPO. Everyone knows World Intellectual Property Organization. Michelle Woods and Yasharya. Their topic is harmonization of AI, copyright, rights protection frameworks. If you are ready. Sorry. I can say again. I want to say again their topic. Sorry for this. Their topic is copyright law division. Michelle Woods and Yasharya. If they are ready, we can start.
Hello, this is Michelle, and I just wanted to say hello to everyone, but in fact, Yash will be presenting for us today, and then I will be available to join him in answering questions you may have. So, should go over to Yash, who has our PowerPoint as well.
Thank you, Michelle. Can we have our presentation, like slides, please? I'll start. I think it's lagging, but it's fine. Good morning and good afternoon to all the panelists and the participants of the session. Our presentation is an update from the Secretariat of WIPO's Standing Committee on Copyright and Related Rights, or the SECR, on the committee's work concerning copyright and generative artificial intelligence. So I'll briefly explain where the issue sits within the SECR, how the 4 information sessions that has happened previously have developed the scoping study on copyright and generative AI requested by the committee, and the next steps which have been identified for SECR 49. If we can go to the next slide, is that possible? So where AI sits in the SECR work program. So within the SECR, the work on copyright and generative AI has developed under the agenda item Other Matters in the broader discussion on copyright in the digital environment. The committee is the intergovernmental forum in which WIPO member states discuss substantive questions of copyright and related, and the Secretariat's role is to implement the mandates given by the committee and to facilitate the discussions. The process shown here has 4 elements: information exchange, comparative updates on legal policy and market developments, a more structured factual basis through the scoping study, and the discussion by member states. Can we go to the next slide? So as we can see here, there is the timeline of how SECR developed. The timeline shows the work has developed in response to successive committee decisions. During SECR 44 in 2023, Group B proposed an information session. The proposal expressly described the exercise as an exchange of experiences and perspective rather than a norm-setting exercise. Then successively through SECR 45, 46, 47, and 48, we had different topics, different sessions. And the topics were like, for the first session, we have impact of generative AI. We were discussing on inputs and outputs. Second session was about comparative jurisdictional approaches to training, copyrightability, etc. Third session was about visibility, transparency, remuneration, licensing, and we also got the mandate for a scoping study. And the fourth session, the latest one, was a member states-led initiative where we discussed about case laws and the recent developments, and I will be discussing about them in greater detail in the following slides. Next slide, please. So what the SECR Secretariat has delivered. The Secretariat's contribution is not only limited to organizing panels, it includes consultation, curation, convening, and documentation. 4 information sessions have been held so far. All the information sessions are in 6 UN languages. And we also have supporting materials made available in all those languages through WIPO's documentation system, and with a public record through documents, speaker profiles, and webcasts. So all of these sessions can be found in the WIPO's webcast, and on the SECR page, we can find all the documents related to the AI info session and other agenda items at the SECR. The programs have also included 4 perspective groups, such as governments, creators and right holders, creative industry peoples, AI developers and platforms, legals and technical experts, and also observers. And the whole purpose is to enable member states to hear different experiences and approaches in a structured setting and to preserve a discussion. Can we go to the next slide, please? So now we'll discuss in detail about what were the discussions at SECR 45, which I call as establishing the landscape. The first information discussed the emerging landscape. It examined the growing use of AI in the content creation and its practical effects on creators, business, and users across different creative sectors. It considered both opportunities and challenges, including the relationship between human-created content and generated material. The second panel looked at enabling factors for beneficial use. This introduced the distinction between inputs, such as the use of protected content in machine learning, and outputs, including the legal treatment of generated material. It also covered technical standards, licensing modalities, and possible new sources of revenue. Next slide, please. At SECR 46, there were again 2 panels. This format was followed until SECR 47. And in the first panel, there was this information exchange became more comparative and more legal in focus. The first panel considered copyright in AI training, which rights may be implicated, how different interests are addressed, and whether exceptions or limitations may apply in particular jurisdictions. The second panel addressed AI-generated and AI-assisted material, including authorship, copyrightability, infringement, liability, and any specific legal or procedural requirements. For example, the Republic of Korea during that session described a government working group that had produced guidance and organized separate work stream on AI training and AI-generated outputs, illustrating one consultative national approach. And previous, like slide 7. Yes, thank you. So slide 7, SECR 47 also talked about visibility, accountability, and participation in value. Again, it followed the same format of having the 2 panels, and the discussion was confined to 2 operational themes, first on visibility and transparency, which was followed by licensing and remuneration. The first panel considered tools such as dataset provenance, labeling, traceability, rights management information, and technical measures. These tools were discussed in relation to making the use of origin of content more visible. And the second panel considered licensing practices, remuneration mechanisms, data-related questions, and technical measures that are being explored by different stakeholders. Can we go to the next slide, please? This was the last and the latest information session. In this session, we had 3 panels, and it was designed as the current state update. So first panel was with member states presented recent national or regional initiatives, including studies, consultations, guidance, legislative or regulatory developments, and policy proposals. In the second, we had experts who provided an overview of developing case laws across jurisdiction. This reflected the growing role of courts in addressing questions concerning training, evidence, transparency, outputs, and liability. The third was we had representatives of creative industries who described contractual tools and practical experience concerning protected content used by AI system. As the result, the committee welcomed the session and agreed that the next meeting should combine discussions of the scoping study that was approved in SCCR 47 with a further information sharing session between member states. Can we go to the next slide, please? So the new SCCR mandate is a scoping study on AI training and copyright, which was a significant development at SCCR 47. The mandate asks the Secretariat to prepare a study on policy or regulatory approaches to the relationship between AI training and copyright, together with related rules and applicable practices concerning authorization, enforcement, and compensation for use. The study should therefore be presented as a factual and comparative resource requested by the committee and not as a recommendation for a particular regulatory outcome. Can you go to the next slide, please? So this slide tells about the envisaged scope of the study. The first part is intended to explain what happens in the training of generative AI models, including the terminology, the use of protected content during training, and what occurs after the initial training stage. The second part is intended to examine licensing and compensation mechanism currently found in different member states, including how training data is obtained, the rights that may be implicated, and the voluntary, collective, or other relevant mechanisms. The third part will survey important case laws and practical litigation issues in this evolving field. Can we go to the last slide, please? To conclude, Thank you. To conclude, the committee has now supplemented the information session process with a scoping study, which will be presented and discussed in the next SCCR 49, currently scheduled for 30th of November to 4th of December 2026. And the Secretariat will continue to facilitate the process in accordance with the mandates and directions given by the member state. Thank you very much. We also have these QR codes, and you can directly reach to the webcast by scanning them. Thank you.
Thank you so much. Thank you. Yeah, it works. Thank you so much, Mr. Woods and Ms. Arya. This is really important for all of us, and we are happy to hearing detailed information from experts like you. Thank you so much. I guess last version, yeah. Yes, we are on the last stop from Ebu, Mikari Evangelista. I hope I say your name correctly. And he is successful senior legal counsel from European Broadcasting Union, EBU, everyone knows. And his presentation is AI and copyright in the European Union. And thank you so much. If you are ready, we can start.
Okay. Hi, Hesra, and good afternoon, everyone. Thank you to Semantani and the whole ABU for inviting me today. So my presentation will be about the, I will give you a framework of the EU legislation concerning AI and copyright, and what the advocacy position of the EBU on this subject. So when an AI system wants to scrape your content to feed the training data of its system, in principles based on copyright law, it requires the authorization of the rights holders. However, in the European Union, we have introduced in 2019 an exception for text and data mining that allows the reproduction and extraction of content for text and data mining for scientific research and commercial purposes. In this second case, when the scraping is carried out for commercial purposes, the legislator has provided the rights holders with the possibility to opt out, to reserve their rights and claim back their copyright. The opt-out must be declared in an appropriate manner, which, when the content is freely available online, has to be machine readable. We have seen over the past years various methods that the rights holders have adopted to express this opt-out. One is to make a statement in the terms and conditions of the website. Here in this slide, we have an example of one of our members that stated that the content hosted on its website cannot be used to train artificial intelligence systems. But probably the most widespread method is to recur to the robot.txt file of your website. This is machine readable because it communicates directly with the crawler of the AI systems. This method, however, is not very efficient because, as we say in the EBU, it's a flag, it's not a shield. So it communicates the crawler that is not allowed to scrape content from the website, but it doesn't actually prevent the crawler from doing so. There is also another concern that we call the granularity issue, which regards the crawlers of the search engine platforms, such as Google. We are worried that by blocking the crawler for AI training, we also block the same crawler that index our website in the search engine results. And the last issue concerning this method is that applies only on the website level. It does not follow the content when this is shared on outside of the website, such as on third-party platforms like social media. And this brings me to the third method, which is a content-based standard, where the opt-out is declared, is embedded in the file of the content. We have various protocols, such as the C2PA, the Content Coalition for Provenance and Authenticity, which is widespread in the audiovisual industry. The advantage of this method, besides being content-based, is also that you can embed other information besides the opt-out, such as licensing conditions to exploit the content. But the problem of these content-based standards is that often they are sectorial or limited to a specific type of content. For instance, certain standards apply only to text, whereas others, like the C2PA, is very easy to apply for audio and audiovisual content. Now, given this panorama in which we have a fragmented use of the opt-out declaration, the European Union has published recently, just 2 weeks ago, a study in which it proposes the creation of a registry to record the opt-out of the rights holders. This registry is not meant to replace the methods that I have listed before, but only to complement the protocols that rights holders have already used. The registry is based on digital fingerprinted technologies that recognize all different types of standards, and it's based on an hybrid architecture. It's both a central resolution layer and relies at the same time on distributed onboarding nodes. Although we appreciate this initiative of the European Commission, DBU and many other stakeholders in the creative industries of the European Union have certain reservations concerning this proposal, especially with respect to its efficiency and the cost associated with the building of such a system. Now we move to the advocacy activity of the EBU concerning AI and copyright. We have two proposals. One concerns the licensing of content by broadcasting organizations for AI training. Given the business model of broadcasters, we distribute programs that contain both our content, for which we hold the copyright, and third parties' content, for which we only acquired a license to distribute. So this prevents us to license our programs to AI systems for AI training, because we will need to seek for the authorization of the so-called underlying rights holders, so owners of third-party content. So we propose to reproduce the cable retransmission regime that has been in place in the European Union for over 30 years, where when a cable operator wants to retransmit the broadcasting signal of a broadcasting organization, he needs to conclude an individual license with a broadcaster on the one hand, and clear the underlying rights through collective management of rights. In other words, by paying collecting societies. We think that this approach that draws from the benefits of both the individual licensing and the collective management of rights can enable broadcasting organizations to license their content and negotiate with AI systems. Then we also propose to complement the existing legislative framework of the EU by introducing a right to remuneration that would supplement the text and data mining exception that I described at the beginning of my presentation. In this case, we would kind of take inspiration from the private copies levy system, where if a rights holder has not declared the opt-out and therefore makes available his content for AI scraping, he will be entitled to a right to remuneration whenever an AI system has scraped his content to feed his training data. And this brings me to the end of my presentation, and I thank you everyone for your attention.
Thank you so much, Mr. Evangelista. This is really an important topic and hot topic also, text data mining exception. Thank you so much again. Our speakers, please wait us, because our audience can maybe ask some questions to you, because all of your presentations are really significant and important for us. Thank you so much, all of you. And today's last presentation is from Dr. Amal, and independent broadcasting consultant and internationally respected broadcast engineer. I guess, we have a presentation, and now maybe we can start. This topic is protection of children in digital and social media ecosystems. It is a really interesting topic because children are really important and we need to protect them in everywhere. So prior presentation also we had a chance to hear something about protection of children. So Looking forward to hearing something from Dr. Amal.
Amama, greetings to you all from Aotearoa, New Zealand. Outline of my presentation, I'll give a quick background to the topic in this conference under the theme and the harm due to the social media as it was recently reported, and some of the stages of intervention globally, because this is one of the hot topics these days. And there are 4 stages I'll discuss briefly with you, and then where those regulatory interventions are in various countries, and then I'll finish off with way forward. I'm honored to be invited and speaking at the IPLC 2026 ABU Intellectual Property and Legal Committee Conference this year, with the theme to explore AI, copyright and royalties in digital content economy. This is a timely discussion of safeguarding original content, tackling digital piracy, navigating platform-driven distribution, and protecting the future value of broadcast creativity. So my presentation falls under the sub-theme of navigating platform-driven distribution. As you know, most of our APU member broadcasters and others now making use of social media and those social media platforms to distribute their content. While we are doing that, our audience also get exposed to the social media content that are coming from other sources, and that's why we are very concerned about this. First of all, I would like to thank Dr. Simantani Sharma, a legal manager at the APU, who is a global expert in this field, for inviting me to talk at your conference. I would also like to thank APU, which is not foreign to me, as I have been closely associated with APU since 1997 in various roles. I'm glad to connect with you all today to address some of the key challenges that the broadcast and media industry faces today, specifically in the area of social media ecosystem. So my presentation today focuses on protection of children in digital and social media ecosystem and regulatory responses. I would like to emphasize 5 words from that title, the children, and who get subject to these harms. Social media, that's the kind of the cause for that, and then how we protect them, the protection, and then regulation, because some action is required for that. So we have been discussing the harm that caused by cyberspace with the increased penetration of connectivity and devices, because in the recent past, connectivity has increased, the affordability and the availability of devices have increased, and this has brought the good as well as the bad. Though we have taken some action to mitigate such harm in the past over the last 2 decades, it can be observed that harms have increased in numbers and also impact they make on those children and families. Hence, it is required to revisit this issue and challenges social media presents and take practical and effective measures. My presentation mainly focuses on an action that globally looking at, that's banning of social media for children below 16. Yes. Our previous discussion provided evidence of a wide range of harm that is caused to children by social media, based on scientific studies by credible researchers and organizations. One of the worst harms of social media has led to the death of so many children. I want to remind you why I advocate for safe and responsible Platform, social media, and digital engagements. I communicated in my various articles and presentations that the technologies are advancing at a rapid pace. Such that the societies, the governments, and regulatory authorities cannot respond at the same pace. Corporations, large tech companies, and profit-maximizing organizations have no concern over the harm and the damage they cause to children, any person, or society as large. I want to ensure new knowledge that what we learn from pure research, technology, how we use that new technology to solve a problem, and the engineering of it, how we work on finding a sustainable, efficient, and effective solution to a problem are used to build a better lives and a better world. I'm an advocate of sustainability and responsible tech for betterment of people. So then now, the harm due to the social media. So as you may aware already, recently US courts ruled that harm caused to children and some of the people by social media was due to the way social media was designed and not the content, because the current regulation that the US had given a kind of protection to the social media, but because that regulation legislation says they are not liable for the content, so it is not about the content, this is about the design. So this is a very important juncture in this one. So it was reported in a CNN online report that a California jury has found Meta and YouTube liable on all the counts in a landmark case that accused the tech giants of intentionally addicting a young woman and injuring her mental health. And I quote, open quote, Meta and YouTube were negligent in the design of their platforms, knew their design was dangerous, failed to warn of those risks, and caused substantial harm to the plaintiff, the jury found. Period. The decision could set a precedence for hundreds of similar cases and lead to major changes in how social media platforms operate, especially for young users, as well as billions, even billions in losses for the tech companies. The case also marks a watershed moment for social media in following years of concern from parents, advocates, and lawmakers about online harms to children, ranging from mental health and concern. So with this, I carried out some research in the public domain to collect data. We call it data mining, related to the banning of social media for under 16 years. So when Dr. Simantani invited me to talk for your conference on this topic, that also prompted me to do the study, and also it was further stimulated when I heard in our media in New Zealand, we are asking young children whether they want access to social media or not. It is good to the lives of children. However, we should be cautious of weighing that input against what evidence-based research and educational sociologists proposed. I learned recently experts treat this issue to a tobacco moment. I'm sure you know how the tobacco has caused harm and how many decades it took to act. It's not yet over. Only the senior generation may remember how tobacco was promoted decades ago, especially in movies, films, society, and how it is. Its consequences are still hurting families and societies. So in this process of the data mining, I kept the harm due to the social media. So as you must, these 4 stages globally, one is the enforced, the other one is passed, and there are the legislation in progress, so that means they are still drafting bills or discussing at select committees at parliaments, like in New Zealand, and there are other countries, those who are proposing. So when they are enforced, law is active, and the platform must comply. And then when the legislations are passed, but the enforcement is yet to begin, and then the progress is still we are in the form of drafting bill. And so those regulatory interventions for various countries, you could see the UK is the only country with powers granted on 9th of March this year. And there are 4 countries. It's good to note that we have Indonesia and Malaysia, both countries from Asia Pacific. The laws are in force. So among all 4 other countries, and also the Australia, which was the leading country who brought this idea up of banning social media for years, 16 years and under. And the bills are in progress in 10 countries, number of European countries, and also in US federal as well. So that means impacting all the states, and also at some other US states level as well. In New Zealand also we are in the select committee stage. And then there are other countries that are proposed, and I'm really looking forward to see how the European Union and also maybe EBU will turn these things at progress. So with those things, some of my recommendation to ABU and to you. ABU is the largest collective of broadcasters, both public service media and commercial broadcasters, commercial media and professional media institutions. So we can collectively advocate and leverage our influence to address this vital issue to safeguard our children from social media harms. So I urge you to work with other collectives as well, like EBU, European Broadcasting Union, African, Caribbean, North American as well, and then all other. So there are 8 of those broadcasting unions under the umbrella of World Broadcasting Union. So we can work together to combat, like we have done in many other issues. So let's work together and try to make some tangible advancement by our next IPLC conference in 2027. So with that, I would say terima kasih. I thank you for patience and listening. Thank you once again, and it was a pleasure speaking to you and sharing my views. So those are my personal views that I shared with you. Thank you.
Thank you so much, the Dr. Amal. Thanks for your presentation and also advices. They are really important to improve our organizations and our perspective, maybe. You mentioned technological developments are really rapid, but regulation cannot follow. I guess it is one of the main problems for all of us, because always legal regulations can follow, but almost all the time in general, we know the technological developments are rapid and we need to catch up. I guess all of us the main problems, because all maybe broadcaster organizations, always people ask, what are we doing? Do we need to do some more things? But also regulations problem. Thanks for all our speakers. And I guess we have some limited time to questions. We are happy to hear some questions from our audience, because our speakers, I guess, except Dr. Amal, they are waiting us. Thank you so much. Do you have any questions to ask our speakers?
Ms. Ezra, can I just make a further recommendation? Last night, there was a lecture in Sydney delivered by the editor-in-chief of Reuters, Alexandra Galoni, and she talked quite a bit about the application of AI to news gathering and how there ought to be a rigorous licensing regime. One of the interesting things that stood out for me was the dimension of the costs we're talking about here that in no way are being remedied at the moment. She was saying that Reuters, for example, in Ukraine and Russia, covering the conflict there at the moment, they have 70 journalists working just in that territory on the ongoing story. Now, the cost of that must be immense. And what's happening is that social media platforms are just scooping it all up, and then AI operators are wanting to use this material as well and also scoop it up. So this issue of licensing in the AI context is a very pressing one.
Thank you so much, Mr. Green. I want to ask our audience, do you have any questions? Or can I start maybe? Because I don't want to wait at our speakers, because maybe time can be really late for them. I'm not sure about this, time differences. My first question is to Mr. Green, for you. Because you said that in your presentation, in today's world, many countries are arguing children protection regulation to adopt. For example, like my country, Turkey as well. But we know that there are many illegal tools, like VPN, many tools, and children can learn about them very well, maybe better than us, unfortunately. So, do you find these regulations are successful or sincere? I would like to ask you, Mr. Green. Thank you so much.
Thank you. The central issue, or one of the central issues, is that of rigorous means of age identification. And I mentioned how Malaysia is leading the way with its rigorous use of official documentation. The difficulty that in some nations, in some jurisdictions, there is not the widespread use of official ID cards or ID identification. I mean, people will have passports, but not all children will have passports. In nations where ID cards are part of the daily life, that is a great step forward in terms of identification. But in Australia, the difficulty, as I was outlining, is that this is entirely based on self-declaration. People can tell lies and say, yes, I'm under 16, but they may not reveal their real age. And parents have been known to take out accounts for their kids, and there's no penalty for parents acting in this way at present.
Thank you so much for your reply, Mr. Green. Maybe I can ask another question to Mr. Wools and Ms. Arya from WIPO, because this topic is really interesting for me, to be honest. And you mentioned regulatory approach, AI and copyright. I'm really curious about your opinion. What is the main problem to this approach, to make regulatory approach, AI and copyright? According to your eyes, what is the biggest problem? Maybe I would like to ask to you. Thank you.
So, Yash, do you want to respond, or shall I? Right, I'll go ahead. Sorry, I think there's an echo. But so from the perspective of WIPO, one of the main challenges in terms of a regulatory approach on AI that we see is the contrast between the cross-border nature of content distribution and the national domestic nature of regulatory activities. Certainly in the European Union, that might be regional, there might be other regional approaches, but in general, there is a concern among both regulators and those who are being regulated about lack of consistency in the regulatory approach and the difficulties potentially in both implementing and complying with regulatory measures. And linked to that is the question of transparency, of knowing what content is being transmitted, including across borders, in order to, once again, apply regulatory measures.
Thank you so much, Ms. Booz. Completely agree, because copyright is domestical, so it's hard to implement, and international aspects to balance is really hard, especially at this point. Thank you so much again. And I want to ask our audience, I understand you are tired, maybe you have any question, or I can continue. Okay, I continue, and my another question to Mr. Evangelista. In your presentation, this sentences, this protection is interesting for me. You mentioned a right to remuneration for content for which no opt-out was declared. I'm curious about, do you have any criteria, or do you maybe study on something? How can we remunerate them? Because we need to, how can I say, determine some criteria to remuneration. I guess it is maybe one of the biggest problem it will be, because it can be sometimes, especially legal aspect, can be really problematic. I would like to ask to you. Thank you so much.
Yeah. Thank you for your question. But like we base this proposal on the private copy levies solution that like we have in place in many countries all over the world. So kind of rely on a system of collective management of rights. So with the support of collecting societies.
I guess members can decide all of their legislation or something.
Yes. Well, for instance, we have our Nordic members, they rely a lot on exempt collecting licenses, and there is a great collaboration with the collecting societies. For instance, for the AI training we have in Denmark, that a new collecting society, the DPCMO, is responsible to collect the remuneration when there is an AI training on content of the publishers. And our broadcaster member operates under the umbrella of this collecting society together with the publisher.
Thank you so much for your answer. And thank you, all of you. These are really, how can I say, beneficial presentations for us. Thanks for your time. And do you have any questions or?
Ms. Ezra, can I just make another brief final comment? One of the discussion points in last night's lecture in Sydney was that the managing director of the ABC, Hugh Marks, mentioned that Anthropic were in discussions with the ABC about licensing Australian idioms, ways of speaking, accents, mannerisms, particularly in terms of ABC drama content and things like that, in order that can be duplicated in an AI context. So I found that really fascinating and takes the whole issue of licensing just a step further.
Thank you, Dr. Green. They are really valuable addiction for us. Thank you for your information. And I guess no one has questions. Thanks for your time, and I hope next time meet in person, all of you. Thank you. Thank you so much.
Thank you. Bye-bye. Bye-bye.
Thank you.
Thank you so much. This is our last session today. Thanks for you, all of you, for your patience and your time. I guess I will give you.
Thank you so much. Thank you to all our speakers who joined us online. It's always very difficult for the Secretariat to find speakers who can come physically, but that's why we try to get all online speakers in the last session so that we can accommodate speakers who are with us here in the first 3 sessions. So tomorrow we will start our meeting at 9:30. It will be on the 6th floor. It won't be here, it will be on the 6th floor. And someone will be there to lead you inside the building, just as today. And I will now give the microphone to Haru-san if he wants to make an announcement.
Thank you very much. And I'm sure that you are tired, so I will be brief anyway. And as I already announced, we're going to have supper this evening starting at 7 p.m. at a restaurant, namely Glovia in Mercure Saban. So I have already received, your responses about that, but I think we have spaces for tables. So if you like to jump in, please feel free to do that. Okay, so see you this evening or otherwise tomorrow morning.
On the stage.